Please give your slips. Let's see.
Mentioning from the list, my lord. Item 23 permitted to withdraw with a liberty to file better.
No, that.
But I could
better application.
I could not submit some documents at the time of filing. I could not submit some relevant documents at the time of filing of a petition. I want to bring by filing a fresh writ petition.
This must be after notice matter.
No, my after notice.
No, no.
They have taken an instruction.
This is a nursing matter.
Item
This is a nursing matter.
You said
Item 23. So there is some document.
Counsel, if you have to add anything, you can fill a supplementary or additional affidavit. But this practice, I have not been able to understand. The practice of withdrawing the application with the permission to file a better application. Your application is there. If you want to supplement, we will permit you. If you want to make an amendment, we will permit you amendment. But why? So this system, I don't approve of.
A simple manner.
Withdrawal, that can be done.
Item 16, the list. Item 16 of the list.
Item 59. That is a BSc nursing course. Your lordship fixed last date to 30th. May pray taken out 2 p.m. Yesterday I mentioned.
It will be taken up. Please inform.
My lord, I am in virtual mode, my
He
lord.
was here.
My lord, I am in virtual mode.
All right.
Is it the only one or other cases also?
No, my lord.
Other
My lord.
Tell numbers.
My case is covered with your lordship's order.
My lord, I may be pardon to mention, my lord, his case is different. He is in the NOC was given on 16th of January. He applied for a new in 20th of January. We are given defect. Yes, ma'am.
Mr. Mohanty,
Yes, ma'am.
without hearing you, we shall not pass any order.
Yes, my lord, I will be there.
We can take up nursing matters at 2 p.m. All nursing
Yes, my
matters.
lord. Yes, my lord.
All right.
Say
Okay,
which is the nothing matter so that council can.
59 and 54.
Oh, the meanwhile they will come.
So those we can post after this.
Yeah.
Give a slip. Nursing matters, give a slip. Which are the matters?
54, 59, my lord.
Table I have given.
Table is here.
Only 54, 59.
Yes, my
So
lord.
take up these matters at 2 p.m. All right.
18 also is there.
18, my lord.
24.
Item 18, item 24.
Where is my
All the
table?
cases are there.
Where is my table?
Yes, my lord, there. I have given.
I have given the table, my lord.
18. All right. 18, 23, 24. So I will mark it, please. So that when the council comes, they can be told at 2 p.m. Please mark
All the
it.
cases 18, 24,
54, 59, my lord.
Yes.
23. We will take up these matters at 2.
Yes, my lord.
Next, mark it.
Item number 1.
Item number 1, pursuant to Lordship's my lord direction, we are filing the affidavit today. I'm serving a copy on my opposite party counsel and also on the government, my lord.
File in the registry.
And the government is also to file an affidavit. I don't file it by tomorrow.
Do it, but do it online.
By
We'll take up the matter after 1 week. In the
1
meanwhile, we go through the matter, the case will retain its position. What do you suggest? Any problem? Yes, next week, first case.
And please file tomorrow and serve a copy. Not that-
it will be done tomorrow.
Serve a copy.
I'll serve copy in advance.
Then counsel for the Orissa Public Service Commission has informed that he is going to file counter affidavit, an affidavit pursuant to this court order in course of the day in the registry. A copy of the said counter affidavit has been served upon learned counsel for the petitioner.
Respondent.
for the respondent. Full stop. Despite this court's order, no affidavit has been filed on behalf of the state of Odisha. Full stop. Have you served copy on him?
Yes, my lord, I am serving a copy on my lord.
Let a copy of the counter affidavit file going to be filed, proposed to be filed on behalf of the OPSC, be served upon and counsel representing the state of Odisha. Stop. Let me, a copy of has been served to the copy of the affidavit proposed to be filed on behalf of OPSC has been served upon learned AG representing the state of Odisha. Stop. The state of Odisha shall be under obligation to file its affidavit by Friday. Stop. It shall take into account the stand taken on behalf of the OPSC in the affidavit, a copy of which has been served upon learned AG today in the court. So please examine what has been, and then you take your stand.
File it by Friday, my lord.
So do it by Friday.
And before that, I will also serve copy.
The registry is directed to ensure that all the affidavits which are filed in the present case are placed on record on the next day. List this matter on Wednesday to be taken up as the first case.
Deeply grateful.
These matters, these matters.
Item number 2.
This matter last occasion, my lord, heard the matter and reserved the matter for orders.
Actually, for delivery of judgment or orders, whatever your arguments are all over.
Yes.
I have also filed the list of citations.
Let it come next week.
Are your notes on record?
Yes, the list of citations I have already filed.
Please see.
Please.
Already checked. Not scanned.
Let it come tomorrow, Vince. Tomorrow,
The same position.
same position.
This short date chart and note may be taken.
Please give.
Item 2.
I'll also go through. I'll also go through.
Item number 3.
May it please your lordships. My lords, your lordships had passed an order on the 7th of August directing that the Learned Government Council should file the counter affidavit within 2 weeks. We would be allowed to file rejoinder, and your lordships gave a fixed date for today and said it would be listed in the top 5 cases. Your lordships may recall that this is that mining lease, my lords, where we have been rejected at the technical qualification stage with a one-line order at page 96 saying that
So
we
whether
have been,
counter affidavit has been filed.
No, your lordship, I need 2 more weeks' time to file the counter, your lordship. The assembly going on, your lordship, with the department. This week is the department's turn, your lordship, so 2 weeks' time.
Yes, Mr.
my lords, there's some urgency, which is why your lordships gave a short date, and your lordship said that given that It would be a short date. We would be protected, my lords.
But there is an interim order, no?
The interim order is only that any action taken in the direction of finalization shall be subject to final adjudication, my lords. And the auction has not taken place, is my understanding, nor to anybody. So if they are taking time like this, my lords, no harm would be done if they are restrained at this stage, given that your lordships gave them 2 weeks.
2 weeks, it will be filed, your lordship, within 2 weeks. We'll be filing it next week, yes, lordship.
1 week.
1 week, we'll be filing it next week.
1 week?
1 week. Yes, your lordship.
1 week, Mr.
Very well, my lords. Then would your lordships give us a few days, let's say 4 days, to file the rejoinder, and your lordships may list it exactly 2 weeks from now. And be very grateful if your lordships could list it within the top few matters like the last time, within the top 5.
Court's order. The state has offered a counter affidavit. 2 weeks further time is being sought for the said purpose. First off, when senior counsel appearing on behalf of the petitioner has argued that considering the urgency of the matter, this court may grant an interim order restraining the opposite parties from taking any further action in matter. First off. Next, considering the facts and circumstances, we grant the state opposite parties 1 week further time to file counter affidavit. Stop. A copy of the counter affidavit must be served upon learned counsel representing the petitioner before filing of the same. Stop. List this case on 2 weeks within first 5 cases. Stop. The time in the meanwhile may be utilized by the petitioners to file and the petitioner to consider this said counter affidavit and file rejoinder if so required. Stop. The observation, then we can say maintain a status quo.
Yes, your lordship.
Very well, my lords. Most grateful.
Maintain status quo in the meanwhile.
I'm most grateful to your lordships.
Yes.
Item number 4.
Most grateful.
Yes. Again, this ITI.
Last 4 items, your lordships, are individual. Last 4 sub items are individual institutes for which I am also appearing, your lordships. And all of them have that representation.
Just your clients have no faith in your first client,
No,
the association. So they have approached separately.
no, that's not the case, your
Okay,
lordships.
yes.
Probably they take the
Yes,
chance.
let us.
Your lordships, almost the same,
So,
same
for-
annexures are there.
for one is association.
Your lordships, 20664 and 24, if your lordship.
Madam,
Is any matter left out which has not been listed or everything is there?
in my matter,
I'm not very sure, your lordship. These are the.
But whatever you had filed is on.
Yes.
All right.
And in fact, all the documents which is there in that is also here. So your lordships will
Just a
find.
minute. Just a minute. So this is one association. those institutions which filed objections, which are they?
These 4 institutions that I'm appearing all have filed objections. In fact, because they filed objections, a re-inspection was done.
Objection, separate objection or that?
Separate, that was there also, this is also there.
All right.
Separate objections they have filed. And in fact, pursuant to that, the re-inspection happened. And even that report was not submitted.
All right. So in all the cases, objections have been filed.
Yes.
Yes, my lord.
Objections were filed in all the cases.
My lord.
How many? 4 cases are there?
My lord. I have.
Apart from objection, there are
I
how
think
many cases?
We are not for
12, I think.
12 cases. 12 cases. In all the 12 cases, objections were filed.
Yes.
Yes, ma'am.
In all the cases, objections were
Yes,
filed.
ma'am.
For example, let us, who is appearing in the second case?
I'm appearing for the second
In the
case, my lord.
second case, all right.
Vivekananda, ITC. That
Yes.
is the WPC number 19924 by 24. Another for Brahmani ITC 199943. Another for WPC Global Industrial Training Center
Just a minute.
2004 of 2.
Just a minute.
My lord.
In fact, we failed to learn stenography. We could not. So we-
You're thinking of one case, so you tell us.
Yes, my lord. And Vivekananda, my lord.
we
In this, yes,
So where is that first notice?
first notice. Your lordship kindly peruse.
Please take your seat, madam. For a while. Yes.
All my terms.
Yes.
Yes.
They have issued the disallowing letter on dated 3/7/2024, that is annexure 4 and 5. Thereafter, my lord.
Just a minute. Just a minute. 3/7/2024.
Yes, my lord. That is disallowing letter. Another disallowing letter also, that is annexure 5, dated 5/8/2024, my lord.
Dated?
Dated 5/8/2024, running page 17.
Just a minute.
Why have you not mentioned all this in your date chart?
Yes, yes, I am.
Highway 2024, where?
Yes.
Last.
Last.
Is that?
Last.
Okay.
5/8/2024. Issue of the letter and bring.
All right. So where is your response to
Yes,
this
madam.
3/7/2020?
Yes, madam. And that is annexure 7 and running page. Annexure 7, my lord. Running page 19, dated 9/7/2024. That is our reply letter for the clarification of the so calls.
Dated? Dated?
Dated 9/7/2024, my lord.
Annexure?
Annexure 7 series, my lord. That visible copy I have already filed in running true copy 19, my lord. The Director, Technical Education, Orissa, request to allow the disallowing the admission academic session 2024-25. Dear sir, on reference report on the subject cited above, I would like to draw your kind authorities as follows for consideration to the allow the admission. The inspection for the post of metric scholarship of our institution carried on dated 2/1/2024, but inspection report of any deficiency is not informed by the inspection authority. That is scholarship matter, that is separate, or DTT till now. So we are not aware to the of the deficiency observed by the inspection officers, but the all norms laid down by the NCBT. Also, we have adequate infrastructure and facilities available as per SKY person for the inspection of the post-matric scholarship on OSSP without any information of the inspection report. Now, how it is possible to comply to defend the report, my lord? The advertisement made DTT on dated 7640 by number 7640 dated 4/5/2024 regarding admission in ITI course portal and mention that the last date to 2/6/2024, inspection date of the advertisement, date of the admission is around 5 months. In meantime, there was no communication regarding the admission. But during ongoing admission, the letter come to and disallowing admission on dated 3/7/2024, which is very unfortunate for us, allow the unjustified local youth and poor peoples. In above fact of circumstances, we sincerely request to consider allow to make which you may kind so shall we grateful to you favor of the sympathizers, and also we assure if you deficiency is raised, then we will comply some of the shown possible, which will not affect in training programs for the any trainees to build their future. Thank you, Principal Vivekananda ITC, my lord. Thereafter, another letter also issue, my lord, on dated 6/8/2024. That is running page 20, my lord. Regarding disallowing the matters, we are giving below the point of the kind on 3rd August, another page. 3rd August, you have sent us letter to comply before 9th July 2024 to give reply why our ITA will not disallow for taking admission for training 2024-25 session. In regards, we have already given you comply letter 9th August copy attached. We have requested you to communicate us to deficiency if any.
So please come to your annexure 8.
My lord, annexure
8. At page 22.
Yes, my lord.
What happened thereafter?
My lord. My lord, in meantime, my lord, the physical verification undated,
That we have seen. Just come to annexure 8. Thereafter, physical verification was conducted.
No, my lord. Only phone verification, mobile phone, whatever you have maintained, only mobile verification, my lord. My lord, what happened, my lord? We are fulfill all the criteria, my lord, because the institution will continue till 2029, my lord. And permanent affiliation, that institution got the permanent affiliation. And whereas no deficiency, nothing else, my lord. Now, the present petitioner institute conducting the AITT practical examination, my lord. I have submitted all the documents in this regard, my lord.
Which is the order? Which is the order against you?
My lord, that issue the letter on dated 3/7/2024, my lord, disallowing the letter for the institution. You are not taking the admission for the session of 2024-25, my lord. Using this, my lord. Annexure 4 and 5.
No, annexure
That
4.
institution got a permanent affiliation, my lord.
Mr. Das,
Madam.
annexure 7 series are your letters.
Yes, ma'am.
Okay. There are 3 letters.
2 letters.
I think there are 3.
Another copy letter. 3 letters, madam.
3 letters.
Yes.
So first 2 that you have sent, there is neither any endorsement nor anything, but the last one you have sent by email.
Yes, ma'am.
When?
On dated 6 August.
What have you stated inside that? On 9th you have replied then.
No, that is
Please read. If you have sent it on 6th.
6. First will comply letter in 9/7/2024.
Page, part of annexure 7 series, that will be page 21.
21.
Don't be in a hurry, go slowly.
Yes.
Don't be in a hurry. First paragraph.
21. On 3rd August, you have sent a letter complied before 9th July 2024. Give reply why our ITI will not be allowed.
On 3rd August, they asked you to give a reply before 9th July. or it should be 9th August.
It should be 3rd of July. Your
3rd
lordship.
of July.
3rd
So on 3rd of July, you sent a letter, all right. Then
6th.
Then taking admission 24 regard to have already given the comply letter 9th August. 9th August रे भी हमें देइथिलु जोटा 9th August.
this is the letter for my objection. So this is what would have been 3rd.
No. You have sent us a letter.
Huh?
This is written by him. Sorry, this is written by him.
Yes. So complaint on the 9th July, that is fine. We have already given complaint letter on 9th August. We are writing to them on 6th August, and how do you say we have completed on 9th August? That is understood? What is the problem?
Yes, that is some typographical mistake.
No, but what is the typographical mistake? First typographical mistake we have
Any-
understood. First, don't be in a hurry. First, we have understood.
Yes.
3rd August should have been 3rd July. That we have understood. What is the other typographical error that you are writing a letter on saying that we have already complied on 9th August? 9th August has not yet come.
6th August another letter issued. That is running page 20. Your lordship kindly peruse.
Which has been sent by email. So that is why we are presuming that that letter has been sent. But something wrong with that letter.
Yes.
Because on 6th August you are sending saying that we have already complied on 9th August. 9th August is yet to come.
Yes.
That may also be.
So what should it be?
All right, where is your
Complaint.
response dated 9/7/2024?
My lord, 9/7, we have clarified all the things, my lord. Because,
No question of clarification. Let us come to annexure 7.
yes, Annexure 7 series, my lord.
That must be 9th August.
Where is your response?
Yes,
to-
my lord. After issuing of this letter of the disallowing letter, 3/7/2024, thereafter, all communication.
So 9/7. So that 9th August should also be 9/7. All right.
And it was received.
Yes,
By them.
on letter 3/7. The disallowing letter is issued to the party on letter 3/7/2024.
3/7, you were asked to send any objection if you had.
Yes, my lord. But in the meantime, we have fulfilled all the criteria, my lord. Nothing, no deficiency, nothing else, my lord.
Why don't you wait for the question to be completed?
Yes, ma'am.
How will we understand?
Yes, ma'am.
Yes.
On 3/7, you were directed to file objection.
Yes, ma'am.
You filed an objection
Yes.
on 9/7.
Yes, ma'am.
So this is your objection as at annexure at page 19.
Yes, ma'am.
This is your objection. So this objection was received. Whether this objection was received
Received
by whom?
by the office, my lord.
By the office.
Yes.
Any endorsement or any number, diary entry or anything? Nothing is there on that letter.
Yes, with the count.
There is something. The left side.
Watch
Okay.
page
9/7, there is a stamp. All right. All this ones in July and 6th August. Yes. So both will be July. Yes, I think both will be July. That makes sense. One information letter came to us.
After 18/7, what happened?
no communication till today. Only this.
So again, you are in a hurry. You yourself are saying that there is a joint inspection
Yes.
on 19 July.
Joint inspection of the over telephonic.
No, but joint inspection on 19 July.
Yes,
Yes. That is not over, that is physical.
yes.
Yes. Thereafter,
There are nothing else.
Nothing what? Another letter disallowing.
Yes.
That is date.
No.
Date 3/7/2024. Annexure
No.
4. Annexure 4, madam. Oh, there are annexure 5. 5/8/2024.
5/8.
5/8/2024.
Yes, madam.
Where is that?
Another letter, disallowing letter. Same letter issued in different date.
November.
2023. It said, sorry, your lordship, 13 November 2023.
13/11/2023. That you check the standards.
Because affidavits have been filed.
No, your lordship has come for the first time, these matters.
My lord, I have filed the affidavit, my lord. Now what happened, my lord? Now the institution declare as a AITT practical center, my lord. If there is deficiency of the infrastructure, how can the present opposite parties issue and declare as a training center and practical center, my lord? And hall ticket, admit card, and practical assessments, all the things I have filed in all documents, my lord. In recently, my lord. Your lordship kindly peruse this affidavit, my lord. If deficiency, how the IT will declare as a AITT center practical examination? That must be cancelled, my lord. My lord, what happened? The institutes are permanent affiliated. There is no dispute of the affiliation. As per the intake capacity, they have taken admission. But in the mid of the sessions, why are you disturbing on data 3/7/2024? That is our allegation, my lord. Nothing else, my lord. For in future other session, they will stop. That we have no objection, my lord. But for the session of 2024 and 25, we have taken 30 to 40% admission ITI because we are as per the affiliation. Because all the ITI got the permanent affiliation. And in this present case, my lord, the present institution got the affiliation in 2009.
Let them file affidavits.
I have filed my affidavit, my lord.
No, it's counter affidavit.
My lord, what happened, my lord? Admission date is 31st August, my lord. If the matter, they will take the admission, only delay, my lord. If otherwise, the petition will infected, my lord.
But you are saying they have already taken admission.
Yes, my lord.
Yes.
I have already taken the
No, you have
affidavit,
already
my lord.
Yes, you have already taken admission. So that we are going to consider.
Yes, obliged. And this session, not for other session, my lord.
You can take only admission regarding this session only.
Yes, already taken.
Yes.
So that's why they are allowing. We this scholarship. The opposite party again and again stated for the scholarship. We are not disputed the scholarship.
Dispute.
All dispute means scholarship. They are providing scholarship. That is, if you are fit or you are get the scholarship. We are not disputed this. We are for the concern of admission in both SC, ST, and general. That is our main
That
present.
you are saying you already taken admission.
Yes, madam.
Oh, last date is.
They are stopping our admissions. In which way they are stop the admission?
Second admission.
For this academic session, in the middle of the
Further
session.
admission.
That is not possible.
See, further admissions we can give, but the student should be made known that this is subject to final decision in the present case.
Yes, obliged.
Right. So
Correct.
it should not create any equity in anyone's favor. And we are prima facie satisfied that your decision is against the principles of natural justice. There is absolutely nothing.
2 letters we have issued without telling them what are the deficiencies.
I should file my reply.
Now you file a reply, but what you have filed from that we have seen.
But in both the verifications, officials of those colleges were there, your lordship.
Nobody is disputing that. But what
Yes.
are the deficiencies?
You should have made known.
Not there in the letter issued to them, not in your report also.
But the second verification, Your Lordship, the deficiencies, they came forward and then a date was fixed for the second verification, Your Lordship. At that time, it was told to them what were the deficiencies.
Where?
And then
Where-
the inspection took place. Your
Madam,
Lordship.
when did you tell? How did you tell?
That,
Orally?
Your Lordship, as to whether they have
Reply,
orally communicated
Filed a
or
counter.
by
You
written.
filed a counter, you've given a table, there's nothing there.
Orally, if they have been communicated or in their presence, the presence, whatever deficiencies were there, if they've been asked to fulfill that, Your Lordship. If
Then
there
they
is
have
no
to-
lease deed, if they've
then
been
they have
asked to
to
give a
sign on a
report.
report
I do
which
not know, Your
contains
Lordship. I have to
deficiencies.
give a specific counter to
You
each of
filed
these
a
cases. Yes, Your Lordship.
reply, that's why we are asking.
An affidavit that has been filed by my learned senior may be served on the state, Your Lordship.
All these writ applications. All given your objection.
Lordships, I mean,
Yes, sir.
your Lordships will
No,
want, I can
in
tell.
your writ application.
Yes,
that is
yes,
not
yes,
that.
yes, because we
Already
had
filed
given,
objection.
because we had given, that is why we were also re-inspected.
Your case.
All of them are on record, your
Same.
Lordship.
All are
Similar, all are similar.
similar.
No, no,
In
we
fact,
are
in-
asking whether you had given an
Yes, yes.
objection. That's
Yes, in fact, your Lordships will find in all my writ applications, Annexure 7 is that concern objection.
yes. Madam, yours annexure, which is your reply?
My lord, under annexure 4 series, my lord, page number 17. Subject, objection and reply for disallowing of admission, my lord, in the year of 2024 and 25, my lord.
3/3, no?
No, all these writ applications involve a common issue, and therefore they have been heard together with the consent of the parties. First of all, the petitioners except the petitioner in WPC number, first case association, have claimed that they are affiliated industrial training centers of state of Odisha. First off, the DT director,
Technical
Technical education.
Technical and
Education and
training.
Training,
Private ITIs,
Yes,
right?
yes.
They're private
The-
ITIs.
affiliated private industrial
Training center.
training centers.
ITC or ITI?
IT the government or ITC the private.
ITC is. for-
Yes.
The DTET, who by a communication dated 3/7/2024 disallow these institutions from giving admission for the academic sessions, academic year 2024-25 purportedly on the basis of an inspection report with respect to continuance for post-matric scholarship on OSSP. What is OSSP? Odisha State Scholarship Portal.
Portal.
OSSP is a state scholarship portal. So, following is the content of the said communication. Body. It is common case of the petitioners that they had raised objection within the stipulated time, comma, in the light of the said communication dated 3/7/2024 against the decision to disallow admission for the said academic year. So stop. It is also a common case of all these petitioners that because of the objections raised by them, an inspection was conducted. So stop. Later, dated 5/8/2024, comma, the DTET, comma, based on joint inspection report submitted by RDSDE. What is RDSDE?
Regional Director of Skill and Development Department, Your Lordship. It's a central representative in the state.
Orissa, an approval. Orissa has an approval of the government in SD and TE department, whatever,
Skill Development and Training.
comma, these ITCs have been stopped from giving admission for the academic year 2024-25. Stop. Next. It is common submission on behalf of the petitioners that the letter dated 3/7/2024 does not disclose the nature of deficiencies which required the DTET to issue later disallowing the petitioning institutions from giving admission for academic year 2024-25. Stop. Further, the communication dated 5/8/2024, though disclose communications, though to the institution, to ITCs, though disclose decision based on a joint inspection report, comma, no such joint inspection report was ever made known to these petitioners. I'll stop. Next. After having gone through, accordingly, it has been submitted on behalf of the petitioners that the decision that the communications dated 3/7/2024 and 5/8/2024 are or have been issued in breach of principles of natural justice. Stop. Next, we are prima facie satisfied with the submission advanced on behalf of the petitioners to the effect that the said communications dated 3/7/2024 and 5/8/2024 are violative of principles of natural justice, in as much as the specific reasons were not made known to institutions, restraining them from admitting students for the academic year 2024-25, 25. The last date for admission to which course is this? To
Electrician and
various courses, certificate courses, various
Yes, ma'am.
certificate courses in the ITC are ITC is 31/8/2024. So stop. Learned counsel, learned senior counsel, and so and learned counsel appearing on behalf of the petitioners have argued that these ITCs should be allowed to give admission for the academic year 2024-25, subject to final decision, final adjudication of the present case. Since after the cutoff date, they shall not be permitted to admit students. Full stop. Next, learned counsel, learned AGA, representing the state, has submitted that there is no illegality in the final decision dated 5/8/2024, final as communicated to these institutions through letters dated 5/8/2024, in as much as the decision was taken after an inspection caused in the presence of the functionaries of the ITCs. So stop. She contends that the action of the opposite parties do not suffer from any illegality. So stop. Next. Be that as it may, considering the specific averments made in the writ applications and the fact that 31/8/2024 is the last date for admission to various courses in the ITCs, we consider it appropriate to direct the opposite parties to file counter affidavits within 2 weeks. 2 weeks. 2 weeks. So stop. Considering the urgency of the matter, the cases shall be listed on 2 weeks within first 5 cases. Full stop. Next. We have been informed on behalf of the petitioners that substantial admissions have already been given by these ITCs before 3/7/2024. So stop. Considering in that background and considering the nature of communications dated 3/7/2024 and 5/8/2024, in the background, also in the background of the fact that these ITCs claim to be permanently affiliated, we direct that in meanwhile, the ITCs shall be at liberty to give admission to the candidates which shall be subject to final adjudication in the present case. First off, the ITCs shall be under obligation to inform the candidates while giving admission that such admissions are subject to final adjudication in the present cases and their admissions shall not create any equity in their favor or in favor of these institutions. First off, in their favor. First off, is this matter on? All right. So that order.
Urgent.
For prayer and fellowships. To take admission, they have to open that admission portal. If you are-
Admission portal.
That
In
then
fact, in that admission portal also, they can upload this order, so
Yes,
they will get it.
Do that.
Open the admission portal.
For, for these 12,
the opposite parties shall be required to take appropriate follow-up action in the light of the present order.
For open of admission portal.
Forthwith, that is the follow-up action.
Yes.
Whatever they do, let them. As regards WPC first case, we are of the tentative view that this writ application by association is not maintainable as different communications have been issued to different institutions which are under challenge, the present batch of writ application by different ITCs.
You need to get the order in the course of the. so that
Yes.
admissions can-
You also please try to do it in the course of the day, so.
Yes, Your
inform
Lordship.
them.
I'll-
Otherwise, they'll have only 3 days.
Yes, only 3 days.
Days. Opening the portal and whatever. The order also posted on the portal.
Yes, Your Lordship,
If they actually upload it on the portal, it will be.
we'll do that, Your Lordship, as
That
soon
will
as
be
we.
follow-up action.
Yes,
No, they will do, but you also have to individually inform.
yes, yes. Oblige.
2 weeks.
Item number 5.
6. 5.6. What are the essence of regularization? Last order passed by my lords to await the final decision of Professor Pavan Dattadar, that is pending for this offense. Just now I received the instruction. The matter has been posted to 14/10 of 2024. That both the matters come after 14/10.
Awaiting decision. As jointly requested on behalf of the parties, list these matters on 5-10 के बाद तो दे दो। 2 weeks. This one.
They are so which day? After that we have to do.
14, huh? 14, 14, 14, awaiting decision.
Sir.
19, 23rd, 23rd, awaiting decision of the Supreme Court in case so and so.
5, 6, both.
Item 7.
Here, man, regarding High Court of Supreme. Already High Court has already been constituted. The diligence that they have come up.
Yes.
Director, that's my name. Thanks.
My lord, kindly one pass over my.
No, no, no.
What order has been challenged?
My lord. Order challenging WPC number 521 of 2024 in passed by
No, that is all right. What is the order?
order is annexed here. It is annexed to one, my lord.
What is the order?
Please.
Mr. Bose, catch your breath, but why you not asking them to read the file? So that is, they can place the facts till you come and.
Are you willing to press this appeal? Please sit, please sit. Please sit for a while. Please sit for a while.
Pani achi.
Please sit, Mr.
My lord, in fact, without recording my concession, your lordship may dismiss the writ appeal. I have done my professional duty.
Very fair.
My lord, if I would not have done, somebody else would have done. My lord, I have seen the order. It is absolutely correct. I'm sorry, my lord, I was late by.
Put to challenge. An order dated 16/1/2024 passed by Honorable Single Judge Court UPC number 521 of 2024, whereby the appellant's petition has been dismissed.
রাত্রি 9টার উপর আসছে 9টা কোরিয়ারে
The Honorable Single Judge has held that the appellant did not have the locus standi to question to challenge the order dated 8/12/2023 of the collector relating to construction of a Gram Panchayat building over the selected land in village Chhadimpal under Jaleshwar block in the district of Balasore. Stop. The appellant has questioned the genuineness of execution of seal deed in favor of the persons who had gifted the land to the Gram Panchayat as void, since the alleged sellers of the land had died long ago. So stop. Next. When single judge, in our opinion, has rightly dismissed the writ application after having taken into account the fact that the execution of sale deed or the execution of gift deed was not challenged for competent before a court of competent jurisdiction, and accordingly the appellants who were the villagers, accordingly since the appellants who were the villagers and did not have any interest in the respect of the said land to raise objection on behalf of the owners in question, did not have the locus standi to challenge of Gram Panchayat building on the said ground. So, this appeal is devoid of any merit and stands dismissed accordingly.
My lord.
Item number 8.
My lord, I am filing the objection. In the course of day, the copy has been sought.
The objection. Objection to
Objection to the writ appeal.
writ appeal. All right.
The delay already condoned.
Delay has been condoned.
Yes.
Yes. What is wrong with the order?
Only issue, non-submission of performance appraisal report to online mode resulted in denial of benefit. Why that has been made mandatory to submit online? Because the last reviewing authority in the General Administration Department in respect of Group A officers. So for promotion to different posts and for upgradation of certain benefits like RSCP, MSCP and other benefits, it is a mandatory requirement to examine the performance appraisal report. So the person concerned has to submit his performance appraisal report, self-performance appraisal report to online mode so that it can be transmitted directly to the General Administration Department because they are the reviewing authority of all the Group A officers. These respondents, they admittedly did not submit. And as a result of which their cases for grant of benefit under Dynamic Assured Career Progression Scheme could not be considered. So they approached the Honorable Court. And however, the Honorable Court directed since they have submitted the hard copy applications, their case have to be considered for promotion and other benefits. Now, one similar matter, this Honorable Court, my Lord Justice Rocco was a party to that, dismissed the writ appeal, and that was carried to the Supreme Court, and that order has been stayed. That matter is sub judice.
We can decide it.
Of a lady, I think.
Yes,
What is the name? Something in K.
that order is there.
No, where is the rule?
That rule.
Instructions. Which is that?
My objection.
No, not your objection. Which is that annexure where you have been asked to give it online?
Annexure 7 to the writ petition. The 7 page 38. The writ appeal.
It's a circular.
It's a circular. Continuation to the department letter dated so and so, and directed to say that online submission bar in respect of group A and group B officers of the state for the assessment so and so has been implemented successfully. The government in this facility and make online part compulsory for assessment year 2015-16 onwards.
As far as I remember, we allowed, dismissed the writ appeal
Yes.
because on the ground that you had given relaxation for group B. You had given relaxation for a particular group. So that is why I think we had dismissed yours. It was a reasoned order.
Yes.
Do you have a copy?
Yes.
That order?
I have.
Notification point.
System of admitting. Yes. Yeah.
Another one.
That is in case of Rajat Mahanti. This is the order passed by the Honorable Apex Court in the Rajat Mahanti.
I remember the name.
Kamalini Bepari.
Kamalini Bepari. Correct.
That order not available.
So that you've not challenged.
That also challenged.
That also stayed.
Yes.
That case I remember, not this. This must have been passed after that,
Yes.
based on that.
Referring to Kamalini Bepari, this order has been.
WA number order dated 28/3/2023. Passed in WA number 731 of 2021. But why?
Lordship, in the meantime, the government has published a notification.
Objection.
There is a copy.
The objection is an ODI.
The annexure is an ODI.
You can read ODI. I want to see what you have written in your objection, whether you are aware of these orders or not. Just to see.
But why the respond? The applicant is so technical. They had to consider the what is the rank of this officer, Doctor?
All are group A.
Group A.
service.
So what must have prevented them from filing online?
Not really. Okay, that will be better.
So many things may not be.
Your Lordship, kindly glance on page 5.
You are not ready to file online applications.
I think you are not aware of the decisions of this court. What is the use of giving an objection? You are not aware of the decisions which are in your favor.
My submission is the government.
Your submission is?
The government has published a notification which is annexed at page 5.
Okay, let us see. Give a copy to him.
I have some.
Mr. Das?
But this is a notification granting relaxation subsequently to those who could not apply. So if they have applied in the meantime subsequently pursuant to that notification, then their cases must have been transferred. That instruction I take my lord on this objection.
You also take whether you have done.
My lord, before that, another annex.
File it in the registry.
And the Odia vernacular notification that the government, that is the decision of the government to do away with the performance appraisal and to continue with the CCR earlier. That's vernacular. So I'll have to.
This is too technical thing. Land counsel representing the respondent intends to file an objection to the present intra-court appeal. Stop. Let it be done. Stop. A copy of this said objection, the objection proposed to be filed has been handed over to land counsel for the appellant today. Stop list this matter on Wednesday.
Item 9.
What have you done?
Find the date chart yesterday. Where?
It is there. Date chart.
That case where, because the name of the mother was recorded in the other brother, so other brother said, we also want to share from that. This is the case.
Yes. If your lordship should see, come.
Parties are appearing. All the parties are appearing.
Yes, my lord, I am the protesting. Respondent number 3.
All the respondents.
Only state is the other. I am the
No, private party.
private party. I am the only private party. Respondent number 3.
Only one private party.
Yes, yes.
Which are- doesn't- Who is Srimati Pradhan?
The wife of Bhagavan.
Bhagavan is dead or alive?
Dead.
And date you have not given.
75. In the year 75.
75 he died.
No, see, I understand from the pleadings of my friends. His case is that the entire land of 36 acres has been recorded in favor of respondent number 3. But respondent number 3 says that in fact he has got only 10 standard acres as per the Euler ceiling. If that be so, his apprehension is that entire land goes to 3 and they have not got anything. That is his apprehension now.
That is the.
Yes, only this is the only case.
Why? I was under the impression you want a share from
No.
name of, sorry, share of Bhagavan.
Yes.
Okay.
He wanted to the share of Bhagavan only because of
I was under the same impression.
your lordship for a moment. May I plead? No, interland. That is wrong.
The name of respondent
No, that is wrong. That is wrong. But
Recorded in the name of respondent number 3 and
mother.
mother. So
So
mother.
who is respondent number 3?
the wife of Bhagavan. Your lordship may kindly see.
Wife of Bhagavan is respondent number 3.
Bhagavan is a dead, my lord, who is one of the son of.
So what is
So, Srimati filed revision case to delete the name of
Yes, Mandaduri.
Mandaduri.
Yes.
That was done.
That was done.
Everything has been discussed. Your lordship may kindly revision court's order.
Just a minute.
Thereafter, these petitions filed revisions
My lord.
stating that for praying for what?
Playing for to add the name of the appellants in the RR.
Okay.
Revision was filed. Revision was filed with those.
Who is the appellant?
Appellant is the son appellant 1 to 6 is the son of a Tuladhara, and appellant 7 is the son of a Brushabha. Legal heirs of the Tuladhara, and appellant 7 is the son of a Brushabha, who is the common ancestor.
Trilochan, 1 to 6 are sons of Trilochan.
My lord.
1 to 6.
All 1 to 7.
How many appellants are there?
Appellants are 7.
All of them are sons of Trilochan.
No, my the legal heirs of the 1 to 6 Tilochan, and 7 is the son of a Brushabha, common ancestor.
This is what appellant is. 7 is Tuladhar.
My lord.
7 is Tuladhar.
Yes.
And 1 to 6 are sons of Trilochan.
Tuladhara.
1 to 6 are sons of Trilochan.
Trilochan. One
Who
of
made
the
the first time nursing Tuladhara?
Listen first. Tuladhara is appellant 7, that is what you said, or it is wrong. Or we can look at the content and find out.
1 to 6 are son legal heirs of Tuladhara. 7 are the legal heirs of the
So
Brushabha.
Trilochan is not there on record. Trilochan or his.
Also not in the records.
Trilochan is appellant 7 or Tuladhar is appellant 7.
That he had said by mistake. Now, as per the record, Trilochan is appellant.
First title is the
Please wait. You had said wrong fact, so that is why I am correcting again. Appellant 7 is Trilochan. 1 to 6.
Yes. So what happened?
my plan is to record our name in the ROR.
This ROR,
That
for the entire property of the share of Bhagavan.
No,
or only one share? Because there were three, in the ceiling case, three units were carved out.
my,
So you want your name in the entire property or only the unit of Bhagavan?
no, entire property has been recorded in the name of
So you have to say yes, yes, not no, no. So entire property has been recorded in the name of Bhagavan.
wife of Bhagavan,
Sorry, wife of Bhagavan, because Bhagavan is dead.
dead,
Entire property.
entire property, along with mother,
Mother has
mother,
died.
mother.
The mother no more.
After death,
Division was allowed.
death of Mandodari, she has filed a revision case before the opposite party number 1 to delete the name of Mandodari. So our view, our prayer is that though I am the legal heir of the Tulodhara and Vrishabha, so our name may be recorded in that awareness. That is our prayer. Before revision as well as revision court allowed the respondent 3 and dismissing the prayer. Therefore, I am filing the writ before this honorable court. This honorable court was dismissed the petition and confirmed the order of the regional court. Therefore, I am filing the writ application. That is the case version.
I had understood it. Yes.
Yes, may I please, Your Lord? Your Lordship, can you see, Vrishabha has 3 sons. Your Lord. Vrishabha has 3 sons. He is the recorded and Tuladhara, Trilochana and Bhagavan. The present respondent number 3 is the wife of Bhagavan. Your Lord. He is already dead. It's not disputed. Then Your Lordship, may kindly see the revisional court order, everything has been directed. That is WPC number 25231. That is page 33, my Lord. Page 33. Your Lordship. But I am just, hello?
Tell us what has happened.
What they have, Your Lordship, may kindly see, while discussing the issue, my Lord, Your Lordship, may kindly see, on hearing the matter on perusal of the copy of the order passed in sealing case number 1675, it has been concluded that late Brusha Pradhan and Mandodari Pradhan had 3 sons, namely Trilochana, Tuladhara and Bhagavan. The landed property of Brusha was partitioned among 3 sons and they were possessing their respective share prior to the sealing case was instituted. During the course of inquiry in the sealing case, given in writing and said a petition which was received by the revenue officer on 31/1977. Her contention was that she was not possessing any land separately and depending on her sons for her maintenance, when she had given up and did not claim separate share from her husband, late Brusha Pradhan. Allotment of sealing units were considered in the name of 3 sons by the revenue officer basing on their separate possession and did not add the name of Mandodari in the sealing unit of Trilochana Pradhan and Tuladhara Pradhan. The revenue officer in his findings mentioned that Mandodari was cultivating the share land of late Bhagavan on behalf of Srimati. So he added the name of Mandodari in the sealing unit of Srimati Pradhan. When Mandodari had no interest over the property of her husband, it is quite inconsistent to add her name with the sealing unit land of son late Bhagavan, which is exclusively allotted to Srimati Pradhan as wife of deceased Bhagavan. So it has been wrongly recorded in the sealing unit of the present respondent number 3. That's why the revisional authority directed to delete the name of Mandodari.
But it has not been discussed if the 3 ceilings they have been
Yes,
recorded
3 ceilings is
separate.
separate 10 acre standard acre are allotted to each sons. Since his husband of the respondent number 3 died, her share allotted to
No, that we have understood. Total land was how much?
total land.
Has not been described in revision code as well as.
So you tell us what is the land?
That is the land lordship, total
How
land is 36 acres lordship. In
Okay.
both
Wait, 36 acres.
36 acres and 92 decimal lordship.
Okay.
As per the RR given before the original code lordship, that is holding number 23 and holding number 98.
So this 36 acres,
Nothing challenge the other RR. If they are allotted to me.
That's
that is
Only
not-
question was to be received.
One thing, his claim is that entire land has been recorded in the name of Srimati, respondent number 3, my lord. So where is that ROR, my lord, recording the entire 36 acres of land in the name of Srimati?
Already given lordship, that is the khata number 23.
Where is that? Where is the ROR? So that, my lord, he is admitting that she is not entitled to the entire land. She is entitled to her share only, my lord. So there is no dispute on this. And he is saying that the correction of ROR, my lord.
And that is the honorable single judge has held that. Then how you are claiming if the mother's name has not been added in your share, how you are claiming the share from the share of Bhagavan, my lord? That is the Lord and
All right.
honorable
Take
single.
your seat. Please take your seat.
May I read the date check, Lordship?
What? No, we will not read your date chart. Just tell us, how do you say that the entire land has been recorded in the name of Bhagwan's? How do you say that? What is the total area of the land?
That total area has not been mentioned in the order of the regional court also.
All right, where have you said that this is the area of the land which has been recorded in the name of Srimati?
Respondent three has filed the division case and.
See, Mr. Counsel, you have the capacity to make any person mad. Because you have not laid foundation of your case and you are not able to answer. We are putting a very simple question that how do you say that the entire land was recorded in the name of Srimati? This is the question. This is your grievance. How do you say? And how can you say?
Where is the ROR? Where is the land?
One series of.
Show us from the one series that entire land is recorded in name of Srimati. Show.
One is the repeat of Lordship.
Sorry.
Yes.
Filed the annexed one Lordship.
Yes, what is written there?
Sorry, this is impossible. Current counsel appearing on behalf of the appellant appears to be not ready with the brief. List this matter on 6 weeks.
You
Yes.
get ready and give a proper date chart. You said date chart, dates are not mentioned anywhere. Dates have to be there on the left side in a date chart.
Problem.
But the order passed by the Tahsildar. Your Lordship has passed earlier order that there is no bar to proceed with the signal. But your Lordship kindly see the order. After I have produced the order of your Lordship, then this is the order passed by the Lordship kindly for a C moment.
Other available to you. Remedies.
Order dated 25/7/2024.
When did we pass the order?
Your Lordship 25/7/24. Your Lordship passed order. 25/7.
He is taking advantage of things. Where is the order?
Ma'am.
Where is the interim order?
There is no interim order. That's why when I paid your before your Lordship,
Your Lordship had not passed an interim order. My friend mentioned that in spite of the absence of an interim order, the ROR is not being corrected. My Lordship had clarified that we have not passed an interim order, so he can pursue his remedy before the authorities. There is no interim order as such explaining the.
Why are you worried then?
because I'm not able to sell my property because I'm.
You sell, who has stopped?
But since the proceeding is pending, that's why Lord.
Can you compel the court to dispose of the writ appeal?
No, my Lord, that is
So
not.
we have in no uncertain terms mentioned that we have not passed any interim order.
Yes. Till then, we, my Lord, Tahsildar is not.
But they could have all settled the matter here, but they could have filed a joint affidavit saying that they will get the share as per the original sealing proceeding. Case could have been disposed of. He is agreeable for their share and they are agreeable for their share.
What is the problem?
I'm saying that joint affidavit can be filed and it can be, the shares can be carved out.
You will not be given the entire land. So they will.
Yes.
Everybody has to be given as
Yes.
per the.
Yes.
Sealing proceeding, the
As
lands
per the
allotted.
sealing, we are ready to accept as per the sealing proceeding. As
ଆପଣଙ୍କର କଣ so you will not accept as per the sealing proceeding.
Your Lordship.
So all are agreed,
Your
so it
Lordship
can
may
be
dispose
disposed
of
of
on
on
that.
that term.
The problem.
yes, your Lordship, on that late dispose of.
Meanwhile, the parties shall be at liberty to resolve their disputes the contesting parties shall be at liberty to resolve their disputes amicably outside the court. Let
And file an affidavit before lawsuit.
Joint affidavit has been filed.
Joint affidavit before lawsuit so that can be disposed of.
if the parties reach compromise, this shall be required to file the terms of compromise by way of affidavit.
Daughters have kept quiet, they are not asking for anything.
No. Mr. Lawsuit upon settle joint affidavit they don't.
Short date, you know.
2 weeks.
Item 10.
As per your lordship's direction, I filed an affidavit.
Yes.
Lordship.
Rehabilitation, that lady. Affidavit copy, has it been served on you?
Yes, sir.
No, we want to see that. What is the present status?
But I have realized that rules are, for the rules not entitled.
Have you said that you will file the affidavit in court?
Last occasion, your lordship direct to file an affidavit ID before the oath commissioner, but not filed it because the affidavit could not be attached with the record.
Affidavit shown on 23rd.
Yes, sir.
After you swear the affidavit, can you make correction?
Uh,
How many years of practice do you have? After the affidavit, make a correction. How can you after that? This was there.
He should find a place that
Will you file?
my lord.
Two separate
you-
affidavits, one for the mother and
Mother
one.
and one for the daughter, as per your lordship. One for the mother and one for the daughter, your lordship.
What card issued by government?
I mean, the family pension.
No,
In,
no.
Man,
Family
in-
pension, what had you written? What
in
card?
ration card. In spite of ration card.
All right, we are reserving order. What is that? We will pass on.
Item number 11.
We should not ignore the law. Irrespective of the consequences.
I'm just returning. Mr. Behra. One affidavit we are keeping.
Yes.
The other affidavit, please make a photostat copy and give that copy. Second copy, you please take this.
Yes.
Please explain to him.
Yes.
See what you have, do you know what have you done? And should we explain?
He will explain, we can't explain.
And that is apparent.
Mr. Samantra, just look at it and explain to him what, we can't take that on record.
Initial like
I have pointed out.
Now see the photocopy.
No, he's seeing the photocopy and Mr.
No, I
Samantra is
original
also.
thing.
No, that is the photocopy.
Oh,
Original is here.
Yeah.
Original, let's say it is okay.
yeah.
Please make photocopies of this and give us the
Yes.
copy.
Yes, sir.
To him and-
Pardon.
I have some affidavit, I have sent to file a press affidavit instead of this. So.
I beg pardon.
All right.
Photostat karigi, please give a copy
Yes,
along
yes,
with the original.
Yes,
And
sir.
also to Mr. Khuntia.
Yes.
Item number 11.
Affidavit has been filed on behalf of the respondent, which has been taken on record. Yes. Other is also respondent. On behalf of the respondent. On behalf of the respondent. Yes, affidavit. Yes. Where is the order?
My case is similar with that case on the basis of instruction of the State Council. This have to discuss the interpretation and this is the orders. At page 48. Relevant for page 49.
What was your prayer? So you could have filed a review application. It's a case of review, not appeal. You can file a review.
I am senior as lecturer, but some admitted juniors to me.
Maybe according to you, this writ application was disposed of
This is instruction.
in the light of an order dated 12/3/2024. Mr. Jena contended. What was your prayer?
I was senior to the opposite party number, to the respondent number, there is the respondent number 4 minus.
Name.
Name
What is the name of respondent number 4?
Dilip Kumar Man.
Dilip Kumar.
Man.
Challenging the appointment of opposite party number 4 as principal.
Principal.
With a further prayer to appoint you as principal come secretary. And you had filed 51 annexures in the writ petition.
And it relates to same VN Autonomous College, Jajpur.
Same college.
It is same college.
Same college.
So whether you were party in that proceeding?
Other writ petition.
No, I was not there.
That order.
Order of detriment 12 till 24 minutes.
Yes.
No, that other writ petition, where is that order?
I was not a party, but the issue was the very same college was challenged. But I was not a party to that case.
Why should we come with it?
So whether Himanshu Shekhar Dwivedi is junior? Is junior to you?
I think that is junior.
Whether Himanshu Shekhar Dwivedi was a party in the writ petition?
No.
In your writ petition,
No.
then how are you challenging his appointment?
I filed the writ petition. The judge, Mr. Dilip Kumar Mahanto was principal in charge.
That matter, you could have challenged his appointment separately, Himanshu Shekhar Dwivedi. Now, see, the person against whom you had filed the writ petition, he was removed. And in his place, Himanshu Shekhar Dwivedi was appointed. And in that background, the single judge held that your application has become infructuous. The petitioner has put to challenge. The appellant has put to challenge. This appeal has been filed. Intercourt appeal has been filed putting to challenge an order dated 24/4/2024, passed in WPC number 40361 of 2023. Stop. In the said petition, the appellant had questioned the appointment of respondent number 4. What is his name?
Dilip Kumar.
Dilip Kumar? Dilip Kumanti as principal cum secretary of Vyas Nagar bracketed Auto College, Jajpur, Jaipur. Stop. Learned single judge has disposed of the writ petition by the impugned order as having become infructuous in the light of an order dated 12/3/2024, passed in WPC number 5193 of 2024 and other analogous cases. Stop. We have perused the order dated 12/3. Learned counsel appearing on behalf of the appellant has submitted. The learned single judge ought to have considered the petitioner's case independently, in the light of his seniority. So stop. Next, the fact, however, remains that as is evident from this court's order dated 12/3/2024, passed in WPC number 5193 of 2024, bracketed Dr. Pramodini Chakra versus State of Odisha and others, that the person's appointment the appellant has had challenged as principal cum secretary was removed from the said post, and one Himanshu Sekhar Dwivedi was appointed as principal in charge of the said college. So stop. In such view of the matter, and single judge has rightly concluded that the writ application became infructuous. In such view of the matter, we do not find any merit in this application. Appeal.
For his own appointment. For the prayer for his appointment. Two prayers. Appointment.
On what ground did you claim that you should be appointed?
But I was senior. I am senior.
Senior most or senior?
Senior and as per the rule and the article of notification of the higher education department, my lord.
When the writ petition had become infructuous to the extent it related to the appellant's challenge to appointment of a respondent number.
Yes. I am not met Himanshu Sekhar Dwivedi.
No.
Dilip.
Dilip forward.
Respondent number 4 as he was also in charge principal.
No, I am
Principal.
the reader.
Dilip Kumar Mahanti was the principal or
Now he is not.
you had challenged, so he's responded number 4.
Whether he was in charge principal or principal.
I am
Regular.
Who's
principal is
appointed?
no, only in charge.
In charge.
Dilip Kumar Mahanti was principal or in charge
Charge.
principal?
Was in charge principal.
All right.
Sure. Stop. Next. This writ appeal is accordingly dismissed.
Get your cost title.
Appeal which is accordingly dismissed. The topic is ruled without saying. Appellant shall have liberty to raise his grievance, to take appropriate legal action if he is denied his legitimate right to be appointed as principal at any stage. We the order.
All right. Regarding his claim for appointment.
We have not gone to the appellant's claim for claim of his appointment as principal of the college.
Item 12.
Yes.
Start from page 23. The operation of page 23, order to get 9/8/2022. Well. And this. Yes. The personal fund button for the agency, the movement motion was proposed by the council. Initially by noted that the July 2024, collected on 55 cemetery but challenge for WPC number 163 for 2024. This could by order detail directly be connected to proceed phase for open motion is taken to the provision of the municipality. Then next para. That of phase notice was issued on 2nd August 2024.
So what happened on 12/8?
My lord,
What happened on 12/8?
no open motion was passed.
The result is yet to be published. That is in cover and it not communicated to me immediately.
Why?
Because I intimated the collector Kalani with your filing of the independent. It was convenient 12-8, but the result has not been published, nor it has been communicated to me. It's filed. On that, for putting this one, the councillors, but no motion is
What is your ground? On what ground did you challenge?
You will see the read between 5 of single judge or CS page 5 grounds for the single judge. Because you are and this
Just
is
one moment.
mirror.
The impugn is pursuant to the second writ application filed by you.
Yes,
The earlier notice had been set aside,
it was secretary.
saying that can do it.
Yes.
Thereafter, when you came up, the learned single judge has dismissed. Because the ground for challenge is that the resolution is not genuine and has been manufactured. So it was genuine and not and manufactured, then they would not have voted. So it depends on what
Section 54 2C of the municipal act.
says that it should be genuine and not manufactured.
No, the collector on receipt of the petition is certainly full or otherwise of the areas.
But that should have been raised in the first writ petition. That should have been raised in the first writ petition. Because. So that is only the notice. Resolution, there is no challenge to the resolution.
Yes.
And once the notice having inquired, placing the self and notice is convening of second concurrent motion is bad. In view of section 64 2C of the municipal act.
What?
Once
So that is where only notice is issued where the meeting has been held. 64C relates to where only notice or where meeting has been held. What is the meaning of that section?
yes. Section 54 no contest against chairperson or vice chairperson. One, then you are provide no such resolution according one to confidence in chairperson, vice chairperson shall be moved more than once during the calendar year. In the instant case, the past notice was issued on 2/7.
First,
Past notice was issued on
Yeah.
7/2018.
this speaks of resolution.
Yes, resolution. Let's see.
Read that section again, that
Yes.
provision again. Slowly.
Yes.
Yes.
For a meeting of municipality, specially convened by the Bishop Michael, in that Bihar, a resolution is passed. Supported by not less than 2/3 of the total number of councillors, recording want of confidence in the chairperson or vice chairperson. Resolution along with the record.
This is not what you read. What you had read earlier, please place that.
Oh, that, yes, sir. Was it section 54 subsection 1
Yes, please read it.
plus 2
Yes,
shall be moved more than once during the calendar year.
that is the subsection says shall be moved.
Right?
The subsection says shall be moved.
No.
Then
No such resolution.
Section 54 and presently provided no such resolution recording want of confidence in the chairperson or vice chairperson shall be moved more than once during the year, calendar year.
So when was the first resolution moved?
On 2/7/2024, annexure 1.
That was cost.
Yes.
Where is the question of moving?
Yes.
the notice has been.
Why
filed.
are you making this assumption?
You see there. Because along with the notice, proposed decision and so-called resolution was
Mr.
not-
Counsel, this contemplates a situation
Yes.
where a no confidence motion is in a meeting.
Yes.
Meeting was not held.
No,
The
meeting-
notice itself was cost. So where is the question of second meeting, second resolution?
Yes.
This
The
relates to
collector-
cases. So that suppose a resolution has been moved, there's a voting
No
and it
confidence.
failed. So just so that it won't be vexatious, they have said in the same calendar year or 2 years.
It cannot be.
So that is why.
Yes.
Okay, there is no meeting, no voting.
Lordships, when working the exam of in Mamata Lehra case, the collect listen and propose this song, the Queen the equivalent voice be set back.
Oh, yes.
Yes.
That's how when I was additional government advocate, I have put some decision. Yes.
No. Lordship, I bring to Lordship, and I said,
See, in this case, we are going to impose cost.
hello?
We are going to impose cost. We must discourage this,
No, because,
such litigation.
I have raised that point in the first.
no, because somebody else was the council.
Oh.
For it to bring it to notice of the conducting council. That was
He
not.
could not have raised that point.
And
in the
Lordship,
first.
he-
He could raise that second notice, could not have.
Because
raised that.
somebody else was the council, Lordship, page 22. madam.
Thinking of. Yeah, but
Lordship, page 22. madam, of the.
Page 22,
Yes.
yes.
First decision passed on 28/6. On 1/7, it was brought to the notice of the collector saying that.
Mr. Joshi,
Yes.
not the first time we are seeing a case. That is the meeting where they have the proposed resolution.
Yes.
So that proposed resolution copy is sent to you. You are saying I was additional government advocate, I have done number of cases. That is why I understand the provisions. You
Yes.
might say something here, but
No, the doing requirement, the collector resolution.
yes,
And the proposition.
yes,
A certain is truthfulness otherwise,
yes.
at least 3 days before the date fixed.
That is why the first notice was, that is why the first notice was quashed.
Each of the councillors.
Mr. Joshi,
Otherwise,
that is why the first notice was quashed.
yes,
Yes.
and signature appended thereon. Thereafter,
This one, otherwise I will impose cost. Yes, dismissed.
Item 13.
Next week, any day next week, Lordship.
As requested on the petitioner, this matter on next Wednesday.
Item 14.
Item 14, my lord, I want to make an adjournment any day next week, as because, my lord, there are certain documents which are to be come on record, my lord. My lord,
And we
will
have
file
filed the caveat, let them
additional
serve a copy
affidavit.
to the land councils. The railway is the party, we have filed the caveat. Mr. Bhokta is there, let them serve a copy to them. And CGC is there.
So this writ petition is against what?
Challenging the inquiry report, my lord, which has been prepared by the opinion and 8 officers.
All right.
Without
Serve a copy on the caveator. As requested on behalf of the.
That is also incorrect, my lord. 7 and 8 is the additional chief secretary of the revenue and forest. Tahsildar,
Who has filed
But-
the caveat? He won't
railway, my lord.
know because he doesn't have a copy. So who
Railway has.
Party number 10.
both of you are appearing for the same party.
I am for the state, my lord. He is for the railway.
Both means
Yes, yes.
My
Along
lord.
with,
My lord.
As requested on behalf of the petitioner, list this matter on. When do you want?
Any date next week, my lord.
2 weeks. Must submit a copy of the writ petition which served on learned on Mr. Bhoktal and CGC.
appearing on behalf of opposite party number 2.
10.
10, sorry.
Saying on behalf of opposite party number 10. Yes.
Item 15.
May it please, Your Lord. Dear my lord, I have been awarded with a contract for construction of, my lord, the academic and administrative building at Rajendra University, Balangir. At page 22, your lordship will find the contract.
Yes.
And as per clause 89 at page 127, I am entitled to compensation cost of escalation. Escalation cost.
Where is the agreement?
Agreement page 22.
There is no arbitration clause.
No, no, no. Here is a question of cost payable as under the terms of the contract. The terms of the contract is as 127, price adjustment.
Mister, even that shall be decided in arbitration proceeding, not.
No, there is no arbitration clause. They have already paid the 3 escalation.
They have paid. We want to know whether there is any arbitration clause or not.
No, my lords.
Have you stated?
There is no arbitration clause.
There is no arbitration clause.
Yes. Page 127 is the price adjustment. And this gives me a right under the contract to raise escalation cost. Because they have themselves raised the project manager has himself raised the bill to the chief engineer, and it has been pending since more than 1 year. Page 170. It is their own letter proposing for payment. Page 170. And this is regarding, my lords, cement, steel, pipe, fuel, and labor, plant and machinery. And your lordship will find that the bills have been paid, running account bills. But these escalation bills have been not paid 4th, 5th, and 6th.
Not given.
And it is absolutely arbitrary, my lord. I've already completed the construction.
Not this matter.
This is 16182.
So should we record that there is no arbitration clause?
Yes, yes.
We are recording that. File your affidavit.
No, well, it's there. Notice will go. This
Notice
is
to go.
They have separate council.
Police housing.
Police housing.
All right. Then counsel, in the present writ application, the petitioner has a grievance that the petitioner is not being paid against cost acceleration of material in terms of the agreement condition of contract at serial number 31.
It is at clause 89, my lords, page 127. 31 is also there.
31 has been read.
Yes, yes. 31 is also there. 89 is also there because that was terms of the tender document.
Stop. Next, learned counsel appearing on behalf of the dispute relates to an agreement dated 12/1/2022 regarding work of construction of academic and administrative building at Rajendra University, Bolangir. So stop. In response to our specific query as to whether the agreement, whether the said contract agreement contains any arbitration clause or not, learned counsel appearing on behalf of the petitioner has, in no uncertain terms, denied existence of any such clause in the agreement. Next, in such view of the matter, issue notice 1 week, 6 weeks.
Item note 17.
I'll put it by registered postman.
Wait, get the order.
The last 5 years, they have struck down all arbitrary clause in the contract.
Maybe.
Item 17.
May it please your lordships. My lords, this is a matter, my lords. The facts are a land acquisition proceeding was initiated by the government of Orissa in the year 6 for the beneficiary Anil Agarwala educational trust. Now that was challenged by the activists before this honorable court. And by the Annexer 5, this honorable court quashed the land acquisition proceeding. Being aggrieved of the judgment, both state of Orissa as well as the beneficiary went to the Supreme Court. I will take your lordships to the judgment of the Supreme Court, which was
Yes.
which upheld the judgment of the Orissa High Court. Now, I'll take your lordships to page 73, para 6. Having heard the learned counsel for the respective parties and on going through the...
Which page you are reading?
Beg your pardon, my lord, that
Which
is
page?
Page 73 of the brief.
Annexure?
Annexure 1, which starts from 28 to 130. I am bringing to your lordship's kind attention to the relevant portion.
Page 70.
73, my lord. 73.
Just.
My lord, Chief Justice got it?
Yes.
My lords. Thereafter, my lords, after framing the issues, how they answered it is lordship will find the relevant page is at 89 page of the judgment. Towards the last portion. We are of the opinion that the High Court has rightly entertained the writ petitions, including the PIL, petitioners, and merely because some persons did not file the objections under Section 5A and or accepted a meager compensation or even accepted the compensation cannot be a ground to set aside acquisition proceedings. That is the next page, that is 90. Then your lordship will be pleased to turn to page 103. At paragraph 64.
Yes.
In view of the clear of law in the aforesaid cases by the apex court, this court has to interfere with the acquisition proceedings and grant of government lands in favor of the beneficiary company to protect the public interest. Hence, we have to answer the opposite points in favor of the petitioner and against the opposite parties. Then, my lords, they answered like this. Page 106, lordship may kindly see.
Yes.
We have answered all the points framed in these petitions against the state government and the beneficiary company by recording our reasons. And we have held that the acquisition proceedings from the stage of initiation till the date of purported awards, which in fact and law not awarded, and the alleged taking over the possession of the lands is in flagrant violation of the statutory provisions of Section 4, 5A, 6, 9, 10, 11, 12, subsection 2, 23 and 24, read with the provisions under Part 6, 7 of the Land Acquisition Act. We have also answered the points that arose for our consideration in the public PIL, holding that the initiation of the acquisition proceeding in favor of the beneficiary company on the requisition made by the Vedanta Foundation by misrepresenting fact and playing fraud on the state government has vitiated the entire acquisition proceedings. We have further answered that the PIL, public interest at large, is affected and that is violation of rule of law. Therefore, we have also held the writ petitions filed by the petitioners as PIL are also required to be allowed and made some observation that the petitioner in these petitions public interest, they have pleaded on behalf of small landholders who have no sustenance to approach the court to fight litigation. Therefore, the acquisition proceedings in its entirety, in respect of persons who have approached this court, and even who have not approached this court, are liable to be quashed for the reason, and that is flagrant violation of the aforesaid provisions of the Land Acquisition Act.
What is your prayer in this?
My lords, after these matters, the state government had not returned it, and I filed an FIR, lodged a complaint that your lordship will kindly see. That is Annexure 2 at page 131 of
What
my
is
brief.
FIR for what?
I have lodged a complaint that those officials who have been involved, an inquiry may be made.
That is different.
Now, my lords, now another thing, my lords, another representation, that is Annexure 4 series can be kindly seen, that I have to be given till they have hold the land still compensation. That has also not been looked into.
Who are you?
I am a activist farmer, or president of the farmers who have lost their land, whose lands have been forcefully acquired.
All right, let them file affidavit.
Yes.
File your affidavit.
There's one thing may point out. First, may kindly come to page 12. That's the last paragraph. Judgment of the Honorable Court.
Page 12.
Yes, no. Petitions number such and such. In the result, we allow the petition was the improved land acquisition proceedings, including the notification under such and such, and land in favor of the beneficiary company, and direct that the possession of the acquired land shall be restored to the respective landowners, irrespective of the fact whether they have challenged the acquisitions or not certain, and thereafter, lords, they shall refund the amount received by them as compensation or otherwise in respect of the land. We also caused the grant of government land in favor of the beneficiary company under Rule 5. Now, what is the prayer? Lords, also may kindly come to page 25.
That we have seen.
So they have received the compensation amount. They will pay back the amount.
Supreme Court has said.
A minute, let him say.
My lords.
They will pay back the amount, take possession, lords. Now they prayed that the lords, instead of lords refunding the amount, taking possession, now they are claiming interim compensation.
So is there any averment that the landowners are willing to refund the compensation amount?
No, I don't know, because there was the direction of the Honorable Court. They will refund the amount and take back.
File on their behalf.
No.
So whether there is any averment that they are willing to return the compensation?
No, no government research in the petition. The entire case is that interim relief should be.
May I again, your lordships?
Just
yes.
Let us think over.
Yes.
Yes, Mr. Samantha, what are you saying?
No, I am saying that this Honorable Court, while quashing the entire acquisition proceeding, directed the land shall be refunded to the landowners, subject to return of that amount, those which have been received by them as compensation and award, milords. Milord, I don't know whether they have not whispered anything, whether they have returned back the amount and they have received back the milords lands, so far as per the judgment of this Honorable Court, milords. But on the prayer, they are saying that milords, interim compensation should be given to us, milords. And who will pay that interim compensation? That's why saying that also kindly look at the prayer.
No, interim compensation under which provision?
That the milords, they are not saying.
All right, file your affidavit, you will see.
Yes, ma'am.
File your affidavit.
Yes, milords, I can file.
If you notice, so accepts notice. Who are the opposite parties?
Milords, I can only appear for the OP number 1, 2, 3, and 4. So far as 5 is concerned, they have to take notice, milords.
Yeah, I'll file.
Who are the parties?
I will take notice on OP number 5 by registered post with AD.
Right.
Only the beneficiary in whose favor the land acquisition proceeding was initiated, which was quashed by this court,
Government.
by the government. So,
No, no.
since he was
No, no. Because possession was delivered. Amount was deposited by the oil foundation, amount was paid to the landowners, and possession was delivered. Now the possession shall be given back by the foundation who was the beneficiary under the Land Acquisition Act.
okay.
And amount will also go to the government taken amount.
Achha.
State or except so except notice on the yes. 8 weeks.
Lordship,
1 week, 8 weeks.
Lordship granted time for filing the reply within
No, we just issued notices. It will come after 8 weeks.
8 weeks.
After
Lordship.
8 weeks. it will-
My lords have issued notice or not?
Notice.
Note.
Item number 19.
Therefore, time, senior counsel engaged in matter suffering from asthma, for which unable to attend.
What?
The senior counsel engaged in this case suffering from asthma, for which platform time for next week.
And the request.
The name of the senior counsel is
As
not mentioned.
requested on the ground of illness of senior counsel,
Mr. Manas Mahapatra.
Mr. Manas Mahapatra, lists this matter on 1 week, 2 weeks.
Item number
Item 20 we have taken up after this,
After?
after lunch.
Why?
Some difficulties is there.
Tomorrow.
item 21. Item number 21.
What is this matter about?
The medical store, your lordship, involves, for the last 2 occasions, have been taken time, your lordship, by the petitioner. Today he has not come.
Last week he was present.
Yes, your lordship. The last 2 occasions he was present.
There is no representation on behalf of the petitioner. Unless this matter tomorrow. First off, it is made clear that the court will consider dismissing the application for default as there is no representation on behalf of the petitioner in the next state.
Item number 22.
No, this case, to direct me to obtain instruction by the order dated 14/8 minutes with regard to annexure 11. Steps taken or decision taken. I've obtained instruction, they've stated that they received that annexure, but on that annexure 11, reply they have not taken any decision as such, and not communicated to me.
What do you want?
Because he has also have not been pleased to issue notice. The case is that he could not respond in time because of his illness, and he did not deposit the amount within required time. So we have not settled the tender with him. He says that due to unforeseen reasons, I could not respond, and admitted case is that. So that's why he made a representation that the annexure 11 is to a so-called notice. So I will file a reply for Lordship Direct. I can file a reply because they requested.
No, you are required to pass an order on the petitioner.
That your Lordship may keep it. I will instruct them to pass an order pending disposal of the application.
That was the only direction. You are required to inform whether any decision has been taken on the petitioner's reply to this.
Exactly, I said that they have not taken any decision on that. So Lordship call it after some time, let the writ application be pending. I will instruct them to take a decision on that representation.
Let's this matter on 2 weeks for an AGA to seek instructions in the light of this court's order dated 14/8/2024.
Item number 25.
My lords, I beg pardon, my lords, in item 21. The court, my lords.
We'll come to our.
My lord.
Yes.
Item 25.
Item 25, may I please your lordship?
24.
Okay. 25.
May I please your lordship? Your lordship, in this writ petition, the order dated 6/7/2024 passed by the Director of Horticulture has been challenged, your lordship. In this case, the petitioner is, your lordship, an MOU was filed between the petitioner and the opposite parties for the development of oil palm, your lordship. And while the
For the
while
development of
oil palm cultivation, your lordship. Lordship, this MOU was filed in 3/3/2006, and while the MOU was still in force and the petitioner had already installed his factory and has been successfully cultivating oil palm, your lordship. Therein, your lordship, the petitioner received this order dated 6/7/2024, as per which the petitioner, along with some other companies, were directed to sign a fresh MOU, your lordship. And as a result of this fresh MOU, the petitioner was directed to pay an amount as towards security deposit and other dues, your lordship. My contention is, your lordship, that the previous MOU is still in force and neither it has been cancelled nor rescinded, your lordship. And while the matter stands thus, the petitioner has neither been sent any notice, neither has been issued a notice, nor any show cause has been.
where is the MOU?
The existing MOU, your lordship. It is in Annexure 1, your lordship. Seven. In the terms and conditions of the MOU, your lordship, it was not mentioned for what period the MOU shall be valid. And the petitioner company has complied with all the terms and conditions of the MOU. Your lordship. Yes, your lordship. It is regarding the commission of the plant, your lordship. Lordship, a related matter is still pending of the self-sim petitioner, your lordship. That is regarding the same oil palm in Koraput district and Raigada district where they were debarred. Because as I remember the case.
Was 22.
Issue that is, I think, WPC.
Certificate, they have mentioned that another application.
Yes, that was the debarment to the districts of Raigada and Koraput, why they were not allowed. Your lordship, if I may clarify, this MOU is regarding Koraput and Raigada, and in that petition, your lordship, what has happened is arbitrarily one of the district was allocated to another company,
Madam,
which I have challenged.
Come to clause 28.
Yes, your lordship.
This is arbitration clause.
Yes, your lordship. Your lordship, it is regarding the dispute related to the memorandum of understanding, your lordship.
Yes, so there is a dispute arising out of memorandum of understanding.
Your Lordship, there is no dispute. Only arbitrarily a fresh MOU, a direction has been given to sign a fresh MOU.
So that is the dispute. You say that your memorandum of understanding is continuous thing. See, come to
Yes, Your Lordship.
and then 28. If any dispute arises out of the memorandum of understanding, so this is a dispute arising out of memorandum of understanding.
With all due respect, Your Lordship, it is not a dispute, Your Lordship. The whole contention is that the state has asked for a fresh MOU even when this is pending. Had there been some dispute and the same would have been communicated to the petitioner, then a dispute would have arose and the petitioner would have gone for arbitration. However, even when the previous MOU is in force, just arbitrarily, Your Lordship may see the impugned order. It's only a notice to sign a fresh MOU without giving any reason as to why such fresh MOU is required to be signed.
So according to you, the dispute which is being raised does not arise out of MOU.
Your Lordship, the dispute
Directly. All right, file your affidavit. Notice. Yes, notice on behalf of all.
No, Your Lordship, I. Yes, Your Lordship, we have.
Yes.
Much obliged, Your
6 weeks.
Your Lordship, this petition may be tagged with the petition WPC number 145 of 2024.
Matter be listed along with WPC number
145 of 2024.
Yes.
Item 26.
No, this order has been completed, it has been given with an order of appointment.
Because your lordship's order has been
Complied with.
that order.
Yes.
Mine.
27.
In item 27, the Tata company has already gone to the Honorable Supreme Court, and SLP has been lost. Diary has been, number has been now converted to SLP lost. Same partitioner.
So no contempt is made out now. It's against whom?
That contempt against, they made all the opposite parties. Because they had claimed benefits under the R&R policy notes.
Tata still has filed the appeal.
Yes, ma'am.
Yes.
In this case, they are appeal but not for.
So the appeal is pending, therefore no contempt lies. Appeal. It's on. It is stated at the bar that an appeal has been preferred before the Supreme Court. This court's order, violation of which has been alleged in the present contempt application. Stop. In such view of the matter, since an appeal has been preferred against this court's order, in our opinion, no case of intentional disobedience of this court's order is made out. Stop. The contempt proceeding is accordingly dropped.
This is the first day. It was not listed earlier.
No.
Orders item 20.
My lords, I finally read without certified copy, my lords. Unless no delay, my lords, after receive certified copy, I file.
You filed an IA for condemnation of delay.
My lords,
Your ground for condemnation of delay.
my lords,
So you had filed the rate appeal within time.
my lords,
But the order you filed
without
later.
certified copy.
What is the delay?
So you filed two counters.
Yes,
The
ma'am.
objection.
Yes, ma'am. I have filed objection.
No, there are two. One objection, one counter. Counter to what?
Counter to the main petition.
In petition is what? The appeal.
Appeal.
You've been asked to file a counter to the appeal.
Yes, ma'am. Opinion number 4, ma'am. I'm first appellate appeal. Already court is directed to approach the authority, commissioner.
Oh, where is the order impugned?
My lords,
Which order you have challenged?
order my lords. Uh, 13/5/2023, my lords.
13/3/2023, not 5.
My lords.
There is nothing wrong in it. The High Court will not punish though the present intra-court appeal has been listed for orders on the point of the limitation, we have considered it just and proper to dispose of the on merits in the background of the nature of order passed by the learned single judge, which is under challenge. Stop. The impugned order dated 13/3/2023 passed in WPC number 7056 of 2023 reads as under. Stop. The learned single judge, in our opinion, has rightly dismissed the writ petition as this court exercising writ jurisdiction cannot punish the public information officer invoking provisions of the Right to Information Act. First off, and single judge has further noted that the the appellant has remedy before the State Information Commission to ventilate his grievance. Stop. Next, accordingly, since there is no merit in this appeal, the same is dismissed. Stop. Delay is involved.
But I am for the respondent number 1, State Information Commission.
Okay. Please.
Item 29.
I beg your pardon, Your Lordship.
You're
Item
Mr.
25.
SR Das or RB Das?
SR Das, madam. Yes, DK Das name may kindly be recorded.
You are Mr.
I beg your pardon, Your Lordship. Item 25, I could not press the IA that I have filed, Your Lordship, for stay of the impugned.
Let it come. Not now.
Because, Your Lordship, the reason I'm pressing is because it has been stated that if I don't file a fresh MOU, then action as deemed fit will be taken against
So
me.
if any action is taken, you file IA, make a mention.
Your Lordship, no coercive action may be taken against me.
Not now. because of the arbitration clause, we are not that much convinced.
Obliged, Your Lordship.
Item number 29.
29, there is a delay of 421 days. The notice is sufficient on the other side.
I am appealing for the respondent matters. Today I am filing my objection to the limitation of petition matter.
File objection in the registry. File it in the registry.
In course of the day, I will file.
Yes. Siddharth file and a counsel appearing on behalf of the respondent. Respondent, sole respondent.
Sole respondent.
Submits that he shall file objection to the IA for continuation of delay in course of the day. This is the case. Have you served copy?
No, but I'll file.
After serving copy on Mr. Sasudas, learned advocate. Full stop. This is the case on today's. This is the case on 11/9/2024. Objection if filed shall be incorporated in the digital record.
Item number 30.
This is that Dase Jaithile Phandiku case.
Rashid, I think notices have gone to a limitation.
Limitation.
30.
Your Lordship, will actually see there is no limitation. That was clarified last time, but
No, but is there any opposite party?
Yes, Your Lordship.
I mean, a private opposite party.
Yes, Your Lordships, in fact, had issued notice in the main matter, but it is gone on limitation. Can I go to Mathura?
So have you filed requisites?
You filed requisites. The memo is also there.
Has notice been issued? Let us see. It is, you're right. There is no limitation. So have they issued notice?
And what was this IE about? 3138?
It was for stay, Your Lordships. Actually, not exactly stay, but allowing him to join in his earlier post. But did the limitation issue come up?
So, office, the registry has pointed out that but they have not placed it. It's there since 3/7/2004 regarding modification of order because there is no limitation. The file has not been put up.
Someone is appearing from the other side.
Oh, notice has
Nobody
not
has
been
appeared.
You sure you filed requisites?
So the memo is there.
The respondent number 3 is not appearing.
No, notice has not been issued. No, that is not sent notice nor issued, not listed the matter.
From the order dated 3/7/2024, it emerges that it was mistakenly recorded that this court mistakenly directed for issuance of notice to respondent number 3 on the point of limitation, though the writ appeal is not barred by
Filed in time.
though the writ appeal was filed within time. So stop. The order dated 3/7/2024 stands modified accordingly. Stop. Issue notice. Issue notice. Whether someone is there to receive notice.
So we'll take it, Your Lordships, by
The respondent 3, they have to file.
a state.
You're saying you already filed requisites.
But then because it was only for the IA, so they took only
Alright.
the Now we'll have to file the whole writ appeals. Only they have taken only for the IA. The costing will only be for the IA.
Yes.
Yes.
1 week, 6 weeks.
What's the IA?
It's 34.
34. So let it be any other day along with
All right, 34, 1 week. Let the matters be called. Yes.
My Lord Chief Justice, with your Lordship Chief Justice permission.
Yes, Mr.
Item number 57.
May I?
Lordship, in the last occasion, my Lord pointed out that uniformity of interpretation.
Right.
That's the passage quoted in Mr. Palkiwala's book, your Lordships. I forwarded to my solicitors, their handover. He refers to the settled legal position.
Thank you.
What your Lordship pointed out is on the respect and humility, your Lordship. Exactly the proposition. Particularly in all India taxing statutes, Lordship.
Thank you.
Lordship, there is one more indulgence we need, your Lordship. We have filed a petition on a similar issue last two weeks ago. The authority is proceeding to adjudicate the matter. Kindly keep it tomorrow for giving ad interim protection like other cases, your Lordship. Same issue, third extension not notified. The writ petition not on your Lordship's board today. I request.
Can we take up the matter on Monday?
The officer wants to pass order by 31st because limitation expires for 31st. Same interim protection which your Lordship given other matters. Same batch, your Lordship. Same issue. Subject to Lordships tomorrow.
So you ask your junior to file a
We'll do that.
tomorrow.
I will. Grateful. I do.
I'm sorry, Milord. Milord, in item 57, Milord, your Lordship was directed to file a counter affidavit stating there in the 57, the notification issue whether the GST council. So, Milord, I file a IA. Milord, I 2 weeks needs for Milord complaints with Lordship because some issues are there.
Such a simple thing.
No, Milord, I understand, Milord, but with the GST council, Milord, some problem are there, Milord. So I have to file a detail after I pay, Milord, file a IA to 2 weeks time. So that can be
IA for what?
For extension of time to file the counter affidavit. In Milord, IA number 11479 11480. Already I filed, Milord. Already filed.
It has been stated by London Council representing
Central GST.
Central GST that an interlocutory application has been online seeking extension of time for filing an affidavit pursuant to the last order of this court dated
28/8/2024.
28/8/2020. 28/2024. So stop. A hard copy of the said application has been filed in court, which is being taken on record. So stop. List this matter on 2 weeks. So stop. In the meanwhile, the desired affidavit must be filed on behalf of the Central GST. So stop. The interim orders shall continue. So where is that?
May I pray? The last matter is Lordship.
Who is assisting Mr. Sridharan?
I'm here.
Have you
Yes,
given
sir.
the
Yes, sir. PK Naik, Milord.
The matter that Mr. Sridharan was mentioning, and the council on record, my lords, I will give the memo, I have given.
Please. Not only about the matter. I was referring to.
Your Lordship, yes. More important is the Palkivara's commentary, Your Lordship. My learned friend is bothered about his brief on hand, but we are concerned with the law, Your Lordship.
Already we have got.
Lordship, yes. May I read it to the Lordships? Page 5 of this, uniformity of construction. Lordship has got that, uniformity of construction.
Yes.
This being an all India statute, uniformity of construction of various high courts is eminently desirable, and considered opinion of another high court should be followed unless there are overriding this for taking a different view. And this is what gives string of case laws. But all India statute, income tax, same thing applies to GST.
Yes. Thank you.
Obliged, it's our duty, Your Lordships. It's our duty. It's our duty.
We have a humble prayer, Your Lordship. Your Lordship's interim order has not been reflected in all the cases, my Lord. We are having difficulties with the authorities, my Lord. May I just humbly pray, my Lord, so the last 3 matters, the interim orders of the Lordship can be reflected. May I just give the numbers to the court master, or in all the matters?
All the matters where your lordships have passed interim orders, that may be extended so that they can.
So we don't have a difficulty with the authorities. And another humble prayer, my Lord, my learned friend, Mr. Satpathy, wanted to file that counter. I'd request his Lordship to ask him, Lord, to circulate that matter.
Definitely. I'll circulate.
That has a huge bearing, Lord, for this assessment year 1819 and 1920. So if there's no extension, Lord, these 2 assessment years, it has to go, Lord.
The last matter, Your Lordship's board bills. Last matter in today's Your Lordship's board bills. WPC 17947 of 2024. This is a fresh matter tagged along with batch bills. All matters interim order there except this one because it is a fresh matter. The same interim order may also be passed in this matter. Same order.
With consent.
I don't think like
Against state.
Central
order or state order?
Same notification dated 28/12/23. All cases interim order except this.
I am appearing on behalf of the state GST. That order is against central GST.
But I have a problem. WPC number 17743 of 2024. Lordship, I'll file an IA. Your Lordship only stated that no process takes taken against the petitioner. But the ask for the notification date ended in this month to complete the proceeding. So if Lordship kindly modify the order to grant stay, or else this IA may be tagged to decide on the last in the final hearing. So otherwise, we are in a difficult position because time will be extended. Your Lordship has not granted stay so far as the proceeding is concerned. So we are not able to complete it. Now, only Your Lordship say that no coercive action as per order dated 37/2024.
Yes, who has stopped from completing the proceeding?
That is
My lords, may I?
37/2024.
So you are not taking any coercive action by continuing.
That clarification of the
that was
because time we have passed, but attempt has been
you don't pass an order, you don't take any coercive action.
Yes.
But you conclude in the meanwhile.
Because the department people has not understand.
No, this department people are not understanding, then they should go and do some other job.
It's not contempt as an issue.
Sometimes you will have to say. Sometimes, yes, innocent people are also convicted.
I understand that.
So you will have to take a stand.
So, permission not can.
Yes, which is your case?
Yes, last matter WPC 17947 of 2024.
Item number?
57,
Same.
last sub-item.
Last sub-item is 17905.
Item 60.
Oh, sorry.
57 last
I'm
item.
sorry. 17947.
Yes, 17947. My friend Mr. Sunil Misra is appealing for state. This is a state GST matter.
When did you file?
Filed on recently because it's a press matter.
So let him see. You will
19th July.
1 month back. More than 1 month back. Interim order, with notice, you have to accept notice, then interim order.
You are accepting notice?
Yes, yes. There is no state against state. Yes, you are also.
Accepts notice, GST and CGST both. Yes, Mr. Vivek
My
Sharin,
lords,
you
for
want
this,
to take it? Please.
my lords, for this IN that was being referred to for passing of the order, my lords, the department is sufficiently protected by Section 75(1) of the CGST Act, which states that once there is a stay in operation, then the time for adjudication automatically gets extended.
No, we have not restrained them from proceed with the matter. They can proceed, but they cannot take any coercive action. So they can proceed. We are not observing. It is open to them.
Your Lordship, in that case, my Lord and Seniors, Mr. Sahu's case, Your Lordship, I may be permitted to file counter with him because in all other cases, Your Lordship, that ground has not been taken. And this case has been filed subsequent to, so that ground has been taken here.
My lords, may I just make a small request, my lords?
Yes.
My lords, my item number 57.6, which is writ petition number 6964, my lords.
Yeah.
And it is a matter pertaining to 1718, where the my lords extension of limitation have already heard the submissions and the judgment is reserved, my lords. There's one more additional point which I want to point out, my lords. In my case, my lords, the case is purely of...
we have not reserved the judgment.
My lords is considering that. So, my lords, the additional point which I want to bring to the my lord's attention is that there's an interpretation of 16(2)(c) matter where the matter is covered by the judgment of Suncrafton, which is upheld by the Honorable Supreme Court, where the particular manner has been prescribed by the board in order to undertake the proceedings or the assessment. And in that case, it means, my lords, when the selling dealer does not upload the invoices on the portal, where the payment has been made, the tax has been discharged by the purchasing dealer, then a particular specific provision and is laid down under circular number 183/2023 too. Now, which is mandatory, my lords. All I am trying to say, my lords, is this, that in those circumstances, all the high courts have remitted the matter back with the direction to comply and undertake the proceeding as per circular number 183, my lords. That is the small submission which I am making right now. I have set out all my submissions from ground number F, which is starting from page number 38 in my writ petition, my lords. And also my reply, which has been filed against...
No, but all these matters are coming after 2 weeks. So you may argue on that day if required.
Please, my lords, please.
Your Lordship, his main prayer against the notification, his prayer is against all these notifications, Your Lordship. And all these cases are against that notification. So let Your Lordship decide notification first.
My lords, I have, my prayers are very clear, my lords. I have specifically prayed also and set out the grounds also that the circular number 183 has not been complied with by. And if 183 is complied by the department, my lords, my grievance would be redressed, irrespective of extension or no extension of the limitation, my lords. Because ultimately, I have discharged the entire tax liability. There is nothing pending against me. All that is happening that the selling dealer has not uploaded the invoices on the portal.
All right. Sorry. Yes.
So, my lords, in those circumstances,
Number 18.
I may be given the opportunity to present this particular.
Surely.
So deeply.
Without saying.
So deeply obliged.
Item 18, 20.
My lord, I am in virtual mode, my lord.
Item 18, sub-item 2, if your lordships can take up the leave.
My lord, I am in virtual mode. I am still having 101 temperature, my lord.
Oh.
So, but I am ready to place the matters management. I don't want to delay, my lord. 18 item 1. I have given the note, my lord.
Just right. Yes, who is appearing
Yes.
in item
My lord,
18?
First item, in this case, I paid for renewal of GNM in respect of GNM course, report 25, my lord. Lordship will find in the exercise, in the academic session 23-24, I was granted NOC, my lord. Thereafter, on due time, I file application and deposit the required fees, my lord. Thereafter, no such intimation from the DMIT regarding inspection. And another thing, my lord.
No, you did not submit your application within time. This is
Lordship
the stand with the.
Lordship may see the page 12 Annex 2 series. I have submitted renewal application on 19th January 2024.
Online or offline?
Online, my lord.
Yes, Mr. Mohanty.
Lord, I want to file counter because 2 days before he has given me the copy, I have sent for instructions to get and file the counter.
All right, so you'll have to wait.
First is the last, then Lordship.
What can be done?
That is only another problem, my lord. This person has gone bypass surgery. In spite, after discharge from hospital, he returned to the DMIT for inspection. They have not hidden to make grievance.
Yes, second.
Lord, second item, if your lordship should take up that WPC 17932.
Yes.
Your lordships may come to 42.
Yes.
Annexure 4.
Yes.
This is a dated 19/6/24, where they say the defect is teaching experience certificate of principal as per required. Whereas if your lords.
My lord, I have filed a counter today.
Yes, I'll place that.
I have filed a counter today.
Yes, come.
Yes.
Yeah, your lordships, that was defect that was pointed out. Then at page 55, your lordships may see why they have rejected my application. They say no fire safety system. But that is, they say in their counter affidavit, if your lordships should see the annexure 5, which is the fire certificate which has been NOC, which has been issued to me, is valid till 25 September. But they say that they have written to the fire officer who was replied on 19/5, that 24/5, that for some unavoidable reason it has been withdrawn. Though that we have not received any indication so far as that is concerned also. But if they had received it on 24/5, on 19/6, when they wrote the letter to us that these are the defects, they could have mentioned it also. But that was also not mentioned. And on that basis, they have rejected our NOC renewal.
So have you replied to the counter affidavit?
I have got the counter affidavit. That is what the stand they have taken. I'll just read out that at para 7 of their counter affidavit.
So what do you want us to now, today?
When did you file the counter?
Yes,
Today I filed.
Today it is not there on the whatever.
It has not come to the court, my lord.
31st is the cutoff date, and they have given a reason in their counter, which doesn't match with whatever they have written to us.
My lord, the only thing is that when we send for verification of the authentication of the certificate, which is up to 25, the fire officer has given the letter that is not.
Mr. Mohanty,
Yes, my lord.
what was the last date for submission of application for grant of NOC? What was the last date?
That was 21/2024, my lord.
20?
January 2024.
24. So as on 21/1/2024, he had the certificate, the institution.
Yes, my lord.
had
Yes, my lord.
certificate.
Yes, my lord.
Then what are you doing?
And also,
my lord, he can produce the certificate now. That is correct from
I have annexed it, my lord.
We'll do
my
it.
Writ application at annexure 5.
But that has been rejected by the authorities who have issued it, my lord. That is the only problem. If now he can get the same letter from them, we have no objection. We will inspect and give the NOC. Because we got the fire department, that authentication is not correct. What is the reasons?
Where is
That
that?
is, I have given annexure.
In the counter affidavit, your lordship.
Counter affidavit I have given, my lord.
Mohanty, then everything is uncertain in this state. See, on the date of filing application, he had the certificate.
Yes,
In
my
the in your communication to the to this college, you did not
Yes, my
make a mention about this deficiency.
No, my lord, it was there.
Later you
Up to-
realize
My lord, it
that-
is up to 25th, it is there. It was there. But we had some doubt. We had sent it for authentication to be verified, and then it has been found. That is what our notification regarding the NOC giving out, my lord, is there.
Then they could have communicated it to us on 19/6.
Fake certificate we can
No.
understand, but if it has
Yes, ma'am.
been withdrawn without information, how will they know?
My lord, that is the what I have told to the fire department to give an instruction on that. What? My lord.
And that was dated 24/5 and the communication made to us is on 19/6 regarding the deficiency. So they knew that if this was the deficiency, they could have written in that, we could have taken steps also.
So, all right, what about, do you have all the system in place?
Yes, my lord.
Fire safety?
Everything is there. Even yesterday also when the matter was there, my lord, I had asked them and they have verified on the website. It's still there, that certificate.
This also is vague due to some unavoidable.
Unavoidable reasons.
Yes,
it
yes.
can be drawn.
That is the reason why.
That is not the reason. Unavoidable reason is not a reason.
Yes, my lord, that is what I have told to the authorities, that this you have to get clarification for which you are facing problems for denying them NOC. I have told them that also after seeing that later.
Yes, state. Is there the party or not?
The state is a party, but I don't know if they have any.
No, but
So-
what do they have?
Yes, they can.
Unavoidable reasons. A certificate is issued valid for more than 1 year. Suddenly you withdraw it saying unavoidable reason.
The fire department has to be
Not
made a
for
party on this.
unavoidable reason.
This is the fire
Meeting
department
can
has
be
to.
cancelled. Meeting can be cancelled for
Yes, ma'am.
certificate.
That is what the fire department has to give a clarification. We have no objection.
17364 of 2024.
17932.
Sorry. Let. First time writing.
First one.
How much time will you require to file counter affidavit in the first case?
We have filed counter.
First one.
First one.
From DMD side, I have already filed my lord. The thing is that fire department has to be made a party and he should get the clarification.
Whether in the first case counter has been filed, who is
No counter. One time.
1 week, as requested on behalf of the DMET. List this matter on 1 week so as to enable it to file counter affidavit. Stop. 17932 of 2024. Stop. In the original case, it is not in dispute that the nursing college in question had submitted its application for renewal of NOC within time. Stop. Its application has been rejected for grant of for renewal of, on the ground of lack of on the ground that it had invalid fire
safety certificate.
As is evident from the counter affidavit which has been filed. Stop. When counsel appearing from the said counter affidavit, it appears that after filing of the application for renewal of license, on the renewal of, sorry, the renewal of
NOC.
The office of the deputy fire officer communicated to the registrar Odisha Nurses and Midwives Registration Council, Directorate of Medical Education DMET, through letter dated 24/5/2024. The fire safety certificate issued in favor of the college was cancelled/withdrawn with effect from 3/2/2024 due to some unavoidable reasons. So stop. And senior counsel 9/9/2000. The certificate, this was not communicated to you?
No, my lord, never. From February even till date also we have not received any communication. And the website shows that it still exists.
The fire safety certificate issued in favor of the college, according to a senior counsel appearing on behalf of the was valid till 8/9/2025. Stop. There was no communication from the office of the deputy fire officer as regards cancellation/withdrawal of the said certificate with effect from 3/2/2024. Stop. Next, in such view of the matter, we direct that let the case of the petitioner/Kalam College of Nursing be considered for grant of NOC, renewal of NOC, irrespective of absence of fire safety certificate, if any, subject to final decision in the present case.
Yes.
Full stop. Next, let an affidavit be filed on behalf of the state
my lord.
Counsel appearing on behalf of the petitioner is permitted to implead let an affidavit be filed on behalf of
That is OP number 4.
Opposite party number 4, stating the circumstance in which the fire safety certificate issued in petitioner's favor was recalled as communicated to the DMET through letter dated 24/5/2024. So stop. It must be stated in the said affidavit as to whether the decision to cancel/withdraw the fire safety certificate was duly communicated to the petitioner or not.
Yes.
Stop. 1 week. 1 week. Yes, 8C.
Please same also, same
Third item
college.
is identical, my lord.
Same.
Same.
Only the course is different.
Nursing के जगह पे pharmacy.
Only the course is different.
Same order.
Okay.
Yes.
Item 43.
23 withdrawn.
Yes, my lord.
Item 24.
24 is my covered by that order, my lord, as I have given, covered with WPC number 2042418 of 2024, dispose upon 22/8/2020. This is regarding that election 5 days, if they have denied.
Yes. 24, 1, 2, and 3, these are covered by.
Yes, 3, yes, my lord, covered by the judge.
So 24/1.
Yes,
Online inspection.
online.
24 is my different regarding principal. Regarding principal, my lord.
This is covered by this. This is covered by this. This is covered by this.
What about the inspection fees? So that is not the ground.
Fees he has already deposited what I have found from the petition. So only he will produce the principal before the authority on 30th. Let him be last date be 30th.
Produce on 30th.
Yes, my lord.
24.1. 24.1. Learned counsel representing the EMET states that the nursing course, it is nursing course.
Yes.
Nursing course.
It's A&M course.
Election.
A&M course.
It is also election.
Yes, sir.
Election, my lord. The judgment I have already given, my lord.
So you will reschedule the inspection.
Yes, my lord. That was 28th. Now this will be last date of 31st. Lord, 30th they let him be present.
That's 20170.
Yes. Over. 4 points. Document date. What is it? What should be the date for this?
At 30th August, my lord.
30th August.
2 and 3.
2 and 3.
Number 4.
4 is, my lord, that election, that denial of inspection.
24/1.
Yes.
20519 of 20.
Yes.
In this case, my lord, I have removed the deficiency within times, but I have given to hard copy, my lord.
No, but you did not submit within time.
My lord. Yes, my lord. My lord.
Neither hard copy nor on soft copy.
Yes, my lord. My lord, today he has given a copy to me. Today he has filed the petition to me.
On 1/3/2024. My lord, they have given the letter. On 13/3/2024, I have removed.
I'll give a counter.
That is not the question. The question is that you had not submitted your application within time.
Within time, my lord.
No.
My lord, Lordship, kindly have a glance at Annexure 5 for a moment.
Annexure 5 to what?
The deficiency they have pointed out, my lord. Deficiency found in the online application for renewal of NOC for the
24.5.
Yes, my lord. Today he has filed the copy to me, to my associate in the court itself, my lord.
Annexure 6 is the.
So today you have filed your writ petition.
Yes, my lord.
Then nothing can be done now.
I will give a counter.
But this is a covered matter, my lord.
No.
Covered, no covered, madam.
If you don't serve the copy, how will he know if it is covered or not?
He has given, I will get the counter, let it come next week.
Is counter necessary?
No, my lord, it's not necessary, but I got information about telephone.
All right.
He has not filed the copy of hard copy.
Well, another 6 that is there.
All right, let him file counter affidavit. 24, 5, 24, 5, 24, 6, 24, 7.
Yes, my lord.
No matter. 24/6 year lordship. WTC 205557 of 24. In this matter, already I have solved the copy on 14/8/2024.
Which copy?
Copy I have solved the copy to
Repetition. But did you submit your application within time for grant of for renewal of NOC?
Yes, your lordship. This is regarding the deficiency not complied within stipulated period. Lordship, time grant annex for 3 series.
My lord, I will file the counter, let it come next week along with this.
Let him file counter affidavit.
Yes, my lord.
I have solved the copy to him on 14. I have solved the copy.
So many counters I have to file.
And
how much time, Mr. Mohanty?
1 week, my lord. I will both all the 3 matters I will give.
Item 7, your lordship.
But my lord,
Let affidavits come.
item 7, item 6, my lord, they had given us how the inspection will be done. They have given us the formula at page 47, annexure 6. After that, they have neither done the inspection nor given us a non-compliance report or any deficiency. Nothing has been done. But after that, they have rejected it, saying that deficiencies have not been complied with.
All right, let him
So
file.
let him
Yes.
file a counter insofar
ma'am.
as that aspect is concerned, my lord. If they had given us, communicated us the deficiencies and
They
whether
will
there
be
was a
filing
compliance.
Yes.
Item
Yes.
sub-item 7, your lordship.
24.7. All these matters will come after 1 week.
My lord, this is
Yes, my
the
lord.
relating to denied for online initiation. But the matter
This is covered.
I am trying to place your lordship.
8.
Or
8 is covered, my lord.
8 is covered.
8 is covered.
My commission, respective commission on 21/3/2024.
Which case?
My lord, item, sub-item 7. Item 24, sub-item.
Let them see, Mr. Counsel, we cannot decide cases without affidavits. Let the affidavits be filed. Otherwise, we will be committing the.
No, my lord, problem is the 31st of your lordship.
We will see what can be done. Yes, to 24.8.
This is covered, my lord. That
Covered.
denial of, yes.
20648.
20.
No, my lord, that is not covered. 20648, your lordship.
20648 is not covered.
No, my lord.
All right. We should dismiss it.
Different, your lordship. They have issued letter to me on 21. 21, they had issued a letter to me on 9th. But the date was fixed for 22 at 10:30 for instruction. How can we know that the email ID, my lord, that is closed when our institution opened on 10:30? It is seen that.
All right, file your affidavit in this case also.
Yes, my lord. Yes, my lord. Yes, my lord. Yes.
24.8. 1 week. Yes.
Item 51 then. 54.
54.
For in 18297 and 18302. I received the counter just now, later next week, madam. 2 matters, madam. 18297.
Just a minute, 1 by 1.
That is sub-item 11. Sub-item 11.
Huh?
So 1 by 1.
Veterinary College of Nursing, my lord.
54, 11.
54.
11, 12.
11, 12.
11, 12.
Oh, now counter 1.
Filed.
Counter 5.
Yes,
Just
my
now received, madam. Counter received.
So what is that? Not because of election or something else?
No, some other problems. Sir.
Some other.
Okay. What is the counter?
No, it was required to be submitted within time. The application was not submitted within.
Oh.
Which happened?
For inspection, I was present, my lord.
This is Betanoti, na?
Yes, ma'am.
Betanoti, my lord. 10 and 11 and 12. Denial for online inspection, my lord.
You are holding the counter?
Yes, yes.
So what is wrong? How do you challenge the decision? We saw the petitioner.
Yes, I am for the
11 and
petition,
12.
my lord. My lord, here, my lord, I was ready for the online. They gave us time till from 10:30, my lord. We waited till 2:30. For there, nobody was present for the DMAT, my lord. Since it was morning office, my lord, 2:30 my staff are left, my lord. 4:30.
So you file reply to the
Yes, ma'am.
11 and 12.
My
Item
lord,
number
sub
11 and
item
12.
My lord, let us start from 51. 54.1.
Just a minute, just a minute. We'll start from 54.1. You're right.
Yes, ma'am.
Lord Counsel for the petitioner seeks adjournment to file reply to the counter affidavit which has been filed on behalf of DMT. Yes, 54.1.
Point 6, 7, 13 and 14, my lord. Just now I received the counter.
Just a minute. So you want to file reply?
54.1 is not your mind.
54.1, I was told over telephone by the council that he will take time, but he has not come. He over telephone told me he should take time.
Today we are filing counter, my lord.
54.1 counter file.
Counter file.
Counter ready.
54 for these matters 1 week. So as to enable and counsel for the parties to complete their pleadings. Yes. So as to enable and counsel for the petitioner to file a rejoinder, the counter affidavit, if so advised. Yes, 59.
59. My lord, 54 last two sub items, no counter has been filed.
Counter has been filed. This is
No,
what
my
this.
lord, we have not been.
Yes.
54 last week.
Last one counter, because my lord, I have received the copy. Today I have to file the counter in this. Last item.
Serve a copy on him. Serve a copy on the petitioner. 54.18, 54.19.
0.19.
Have they filed?
So the last but four item, fourth item, right? If Lordship looks at WPC 18543 of 24. 18543.
Item 54.
54, last.
Item 15.
Yes.
Yes.
Last item.
18543 of 2024.
Yes.
This is something different than the cases that have been
All right.
kept
My lord.
Counter affidavit.
My lord, this is a case where he wants to get examination students to be taken examination.
All right.
Forms to be filled up. The separate counter I have to file.
54.15. How much time will you take to file counter affidavit?
2 weeks, my lord.
54.15.
Yes, my lord.
Satyanarayan College.
Yes, my lord.
2 weeks. Time is allowed for the DMET to file counter affidavit. This is on 2 weeks. May it please, Lordship.
They should serve the copy, but actually he is filing counter without serving.
Let us
serve copy.
No.
There are so many matters.
We'll file counter.
It's not easy.
We have not filed. I will file. When I filed, I served the
didn't know
copy.
that there are so many nursing colleges and
Yes, my lord.
pharmacy colleges.
The interior part of Kalahandi and Koraput and those.
Here also the physiotherapy colleges and as well as the other, all are there, It's not only nursing.
Nursing.
So
Yes.
Item 59.
Just a minute, just a minute.
Item number 54, sub item number 16 minutes. Read petition number
So
18877.
you don't want to file reply?
We were supposed to file.
Counter affidavit?
no counter.
My lord, my,
Common order
my-
so that you will file your report.
No counter.
no, my lord.
Some copy
My
of
lord.
the counter
Yes,
affidavit.
So fix a
My lord,
date.
I have not filed the counter in this case. This case previously he has filed one case WPC 12963 of 24, which he has withdrawn in the month of June. Then he has filed this petition. I have to give a full counter in
Liberty
this
to file
case.
a fresh one because I was given a liberty to approach 1 second and for a session 24-25, which I
So I have to get in. I have to get a counter to this.
Which item?
Which item, Mr. Manti?
Item 16, BB Chhatwis School.
54.16.
So you have filed counter affidavit?
No, my lord, I have not. Just recently I have got the writ petition. I have gone through that. That's why I want to take time.
Oh, 54.16. 1 week. How much time?
2 weeks, my lord, because I have to verify the other petition and see that what has been
2
done with
weeks
that.
time is allowed. And counsel for the DMET to file counter affidavit. Why have you mentioned in the chart that you have filed counter affidavit?
Counter to be filed, my
To
lord.
be filed, sorry.
Yes, my lord.
Counter to be filed.
My lord, item 54.6, 7, 13 and 14. Just now the file counter, I received the copy.
File your.
Next week, your lordship.
Yes, sir.
Item 54 sub item.
1819, I think my Mr. Like Monty, I think he said he will file the counters
In which case?
today in 54.18 and 19.
19 counter to be filed. Yes.
Yes, my lord.
54.18 also.
How much time will you take?
2 weeks, my lord.
2 weeks.
My lord, 54 sub item number 4, my lord. Also, in this case, no counter has been filed. That is Zenith School of Nursing.
I have filed the counter. Copy has been given.
Copy has not been given.
Then he will give it to you. He is there, he will give it.
My lord, I will file my response.
Item number 10.
54.10.
Yes, one.
Yes.
There was the instruction to file the counter, my lord.
So they will file counter affidavit.
Yes, my lord. Yes, my lord. I will file the counter in this.
54.8 and 9, both matter. In my Institute of Nursing. Today they are filing counter affidavit.
File reply. Yes.
Item 59.
59, I have already filed the counter in the Mahatarani, my lord, today. Today I have filed.
Regarding that email ID.
Yes, my lord. Counter I have filed today.
Was made when we submitted the deficiencies. Since there was a glitch in their ID, and there is not that we are the single college, there have been other colleges also. So we submitted from a different mail ID because the registered ID it was not accepting. So while giving the reply, they have not given in a registered ID, they have given in the new ID. So that was why there was a delay in compliance with the deficiencies. So on that basis, they have rejected our applications for renewal.
I have filed the counter, my lord, today in this case, my lord.
Counter affidavit has been filed.
Yes, my lord, we have received it also. Not today, they have filed on 10/8, in fact. So we
So you are not required to file reply. All right.
Same, the issue is covered also, my lord. No, same issues are there that regarding the glitch of their.
Have we decided any such matter?
No, my lord.
No.
Same issue, it will cover, my lord, all that.
All right. When do you want? Next week?
Next.
My lords, I think what my learned
in
friend
one
said,
case,
there is in one case,
in
you also
my-
decided this.
I am concerned with the sub item 4,
Sub item 4, yes.
17494.
Yes.
Your lordships, in Biswas case, WPC number 16,986, extended time till 31st August 24. I am reading your lordship's order. In view of the order, which has been passed today in IN number 972424, arising out of WPC number 39868 of 23, in the court's opinion, the grievance of the petitioner stands redressed
as the court has permitted DMT to accept application for renewal of NOC up to 31st August 2024. But much before that date, stipulated time, we have applied, but only for 6 days delay occurred for compliance.
My lord, this is a different case. My lord, this case is that on 16th we have given him the NOC and he had 4 days time on 20th and the last date he has applied for the 24-25. We have gone through his application. Deficiencies we have communicated. He has not responded in time. This is not a case of Biswas that after 20th he was having no chance to apply for the renewal. He has applied and we have taken into consideration. Deficiencies has not been given in time. That is what I have given my counter.
Your Lordship's order at page 39 in Regender.
I have given the counter.
Which case?
In sub-item 4, my lord.
WPC 17494.
9.4.
I'm giving extra copy, my lord.
Give us. No, but is this your submission that we have extended the last date for submission of online application up to 31/8? Is impossible.
Your Lordship kindness.
No, my lord. It's not that.
Is a flat 20 additional fees.
He has already applied in time.
In para 3, your Lordship kindly see, first NOC was granted on 16/1/24, as like Biswas. NOC for 2024 was granted on 16/1/24.
This is the wrong order. This order, there is some typographical error. This should not be. Have you seen, Mr. in Viswas case?
Yes, my lord, that is what.
No, but that order was. That is in different context, Mr.
Yes, my lord.
Are
Yes,
you
my
relying
lord.
on this?
Yes, my lord.
Your Lordship extended all applications.
No.
35.
No. Sorry. This is not how.
Here is only 6 days delay for
We
compliance.
expect something more, Mr. from you. How can you do this? This order was passed in a different context altogether.
Yes, my lord. Yes,
Not
my
that
lord. Yes, my lord.
If you
Yes, my
interpret
lord.
the order as if in all cases,
No.
then it will become an endless situation.
No.
Calendar.
My lord, he has already applied in time. And by 20th. That is there in his
Already
application.
applied then.
Yes, my lord.
First case, we have filed our additional affidavit in response to their counter affidavit also, which is on record.
I'll go to that.
All of the reasons.
We will consider now case to case
Yes,
basis. So no further grouping
No further grouping, my
or
lord.
disposal. We are 59.4. 59.
Yes, my lord.
Counter affidavits have been filed in 59.1, 2, 3, and 4.
Yes, my lord.
So we will take up case wise. And then 59.5, who is appearing?
I am appealing 59.5.
59.6.
Counter, my lord. I will file my reply.
I have today filed counter.
Whatever.
59.5 and 59.6.
Yes. Okay. Do it. 59.7. 1 week. इसमें counter file. Proceed to file rejoinder. Yes.
$59.1. Your lordships are taking up that item 50.
59.1 we will take up next week.
Yes, my lord.
59.4 also, 0.4 also to next week, my lord.
Yes. Next week. Such cases in which counter affidavits have been filed, you can file your reply. We will consider now case.
Yes, my lord. Yes, my lord. Yes, my lord.
But I have a small submission. On your cases, the Indian National Council is a party, let them serve a copy. They are only sending the order and the council is blanket about the prayer, all these things. These are state matters most probably, what I've heard from the.
I'll ask them, we can ask them to delete you.
Yes.
Yes, yes. Where decision is not
Or
required.
not necessary, then you can delete our Indian Nursing Council can be deleted also. Yes.
All right, Mr. Patil, Senior Deputy Solicitor General of India has submitted that Indian Nursing Council is not a necessary party. See, not a necessary party. See, necessary party in the matters relating to grant of no objection certificate or renewal of no objection certificate. So listed aspect shall be considered on the next date. Any. All right.
Item 31.
Item 31, on behalf of Mr. Patnaik, pass over, my lord. On behalf of Mr. Patnaik, appearing for the respondent, pass
I
over.
requested on behalf of the, unless this matter on.
My lord, it is
1 week.
only
Matter
to
we had
dictate the
yesterday.
order, my lord. Yesterday it was heard. It is today only for dictation of the order.
Yes. Tomorrow, Colonel. Tomorrow.
My lord.
Item 32.
Your Lordship, kindly look at order number 20 dated 24/6/2024. Order number 20 dated 24/6/2024.
32. Yes.
Yes. Let an affidavit be filed with the Secretary Orissa Housing Board, Bhubaneswar, OP number 1, giving the names and address of the person who are holding the post of Chairman, Managing Director of Orissa State Housing Board, Bhubaneswar, from the date of passing of the order, that is 6/7/2010 till date. The said affidavit must be filed by such and such date. Secretary of the Orissa Housing Board shall be required to be personally present on the next date. The court is prima facie satisfied that not only those containers have deliberately disobeyed this court's order passed in WPC number so and subsequent order passed in the present contempt application, they have attempted to mislead this honorable court to avoid the rigors of the contempt case. On the next date, the court will consider the issuance of notice to all such persons responsible for deliberate disobedience of this court order for the purpose of framing charge of contempt of court against them. Then the last order, also kindly see, on 30/7/2024. That is order number 22. It is stated by Mr. Milan Kanungo, order dated 37.
Yes.
It is stated by Mr. Milan Kanungo on a senior counsel appearing on behalf of the contender Orissa State Housing Board, Bhubaneswar, that a proposal has been made to the state government for making available of the plot which was originally allotted in favor of the petitioner Alek Chandra Padiari. Petition number 3. Alek Chandra Padiari. As in the fact and circumstances, the permission of the government is required. We have formally not initiated contempt proceeding against the officials in view of the assurance which has been given on behalf of the contender to resolve the issue which got complicated because of certain development amicably. We make it clear that once we are satisfied the court's order dated 6/7/2010 passed in WPC number so has not been complied with, the court shall have no option left but to proceed against the officials in the present contempt matter. Now an affidavit has been filed by OP number 1. Let me kindly look to that. And they have enclosed an order of the government at Annexure C. This affidavit has been filed in the contempt application on 13/8/2024. 13/8. You also look to that. They have enclosed the copy of the government order. That government order is on 12/8/2024.
Last time.
Yes.
You also get it?
Yes. Which page?
That is, in fact, the affidavit filed by OP number 1 on 13/8/2024, page 3. That means that is only one annexure they have given, that annexure C.
Yes.
Page, may I read it? This is a letter from the Director Housing Board to the Managing Director. Madam, with reference to your letter dated so and so, I am directed to say that after careful consideration of the proposal of Orissa Housing Board, the government have been pleased to observe and advise the following points in connection with the contempt case arising out of WPC number so-and-so filed by DPSA. The proposal of OHPC with regard to construction of 6 number of duplex core houses had been turned down by the government long after the decision was taken by the government. And it had been categorically instructed by the government that OHSV should float a social housing scheme for LIG and EWS category over the said plot. 2. Despite such instruction by the government, which was primarily intended to benefit the underserved and economically weaker section of society, Mr. Alexander Paderi appears to have influenced the board, taking advantage of a official position as director of housing board for undue personal gain. Then 3. OHSV they therefore advise to stick to its earlier stand and allot the petitioner, Sri Alexander Paderi, a plot out of 3 plots offered to him earlier at notified price or refund the amount paid by Sri Paderi with interest would made to him. If your lordship will, I have prepared a affidavit also, additional affidavit.
You're the director housing?
Yes. How can he write such?
No, you.
Myself?
Yes.
No.
Then what is this?
No. I was.
Government says he was the director of housing.
Not. That was way back. He has retired in the year 2008.
But you were director housing board?
I was housing board at that time, but subsequently at the time that is you also look to this. They themselves have. If you also will see that I'm giving the affidavit.
When were you director housing board?
I was director. Not at that time.
What time?
I'm giving.
That means he must be one of the.
Yes.
Vigilance case also pending against me.
That is
No.
Hello, I can give it on affidavit.
No, director, I mean, vigilance.
But I don't understand if but I was not that. I am filing an affidavit. You also said that I'll file an affidavit that I was not director at that time.
No, that is not the question. Question is the circumstance in which the plot was allotted to you.
This was a. You also see that scheme. You also have already heard the matter. That is
Yes,
a lottery.
we remember everything. We remember everything. But when the government says that despite such instruction, proposal of
Sir, this instruction was much after the order was passed by this court recently. You also look to that. I have given my affidavit. They have already recalled that order. You also look to that. I have given the copy.
Recalled under what circumstance?
No, you also look to this instruction which now they have referred to. That is long after this is a way back into this order was passed way back in 2010. Now they have given this instruction in 2023. And then thereafter, during the contempt application, they have already recalled that order. Look to phase 7.
First time, Mr. Is it not correct that for the first time we are learning that you were the director of the housing board at some point of time?
No, that is not correct. I'll file specific affidavit that I was not at the director.
No, at any point of time, whether at any point of time you were the director of the housing or
I'll file affidavit to that.
File an affidavit.
Accepted and gone. You have continued.
I am continuing because 3 persons were there.
Yes,
so far the petition of this petitioner is concerned, petition number 3, he is continuing.
Exactly.
That is it. So far petition number 3 is gone. Others
Deal with this affidavit. So very serious. It takes a turn.
Yes, sir. I'll file an affidavit. I'm ready. I was not the director at that time.
We are not asking that time at any time.
There is no question of that time. The question is at any point of time.
No, that I have to take.
Because the manner in which this case has taken turns from one stage to another, so generates serious doubt.
I'll also keep it to some other because he's ill.
Whenever
he's in Bangalore.
It's all right.
That's
whenever.
Also keep it to 2 weeks after.
And when we will have to test. So, do you have any idea when was he director?
Yeah, no, I'll file the specific.
In view, senior counsel appearing on behalf of the petitioner seeks adjournment to file reply to the counter affidavit
It'll be 3 weeks after, because he's
to
in
the
Bangalore,
affidavit.
he's ill. I was
The
told
affidavit.
yesterday, so that at least I can.
Filed on behalf of, to the file on 12/8/2024 on behalf of the Odisha State Housing Board. Alekha Chand, who is Alekha Chand Padiyari?
Yeah, he's the petitioner.
Continuing the contempt application, others have withdrawn and taken the money and gone.
All right. This is matter on 3 weeks. 3 weeks.
Oh, he was here 2 weeks back, but now he's gone back.
Yes, please.
Item 33.
She is present in court.
So answer is personally present in court. First of her personal appearance stands dispensed with for the present.
Okay.
Last week or last week.
No, see me.
Okay. Then was a personal appearance directed today?
Yes.
Okay.
Personal appearance.
Was she directed to remain present today?
Yes.
Okay.
So we have dispensed with.
Well, obliged.
Item number 33.
33, my lord, it's that school, primary school matter. I'm sorry, last date I could not make myself available. Pursuant to my lord's order, dated 26th of June 2020.
They filed an affidavit on 7/8/2024.
Which is pursuant to my lord's order dated 26th of June 2024. They have filed an affidavit of 958 pages and served me a copy on 12th of August 24. So
Consider. We are very happy that something
has progressed.
Something good has happened.
Good has happened. They on affidavit say that they have uploaded this information in website.
Very encouraging.
That is encouraging, my lord. I am really happy about this. Your lordship also equally.
Just examine.
Lord, I just want to say one more. They have uploaded 24,000 some odd schools. They in their affidavit say that 47,000 some odd schools are there. They are in the process of uploading. They are working on this. Lord, I will work on this. There. So far affidavit I have received, I will work on this, my lord. So far the rest, let them also work on that. Let them also file appropriate affidavit. Let us work together, my lord, whatever.
So ask your juniors to work on it.
Right, me. I'll do.
Yes, sir.
Yes, my lord. Your lordship has seen that paragraph 5 of my affidavit. Affidavit, your lordship, is paragraph 5.
Yes.
It is to mention here that joint review meeting with all CDO come use of chief development.
Paragraph 5.
5 of my affidavit filed on 7th August, my lord. A bulky affidavit
is not
containing 958 pages.
That it takes 9 days to.
Internal page 3.
Internal page 3, paragraph 5.
7th August, yes. Paragraph?
5, my lord.
Paragraph 5 is something else.
Different.
The block education officers.
Yes, my lord. Yes, it starts from the block. I am reading by the middle portion.
Which part?
Middle paragraph.
Middle part.
Yes.
It is to mention here that joint review meetings with all CDO use chief development officer come executive Zilla Parishad, district education officer, block education officer, senior technical consultant and cluster research and coordinators has been conducted division-wise jointly by Odisha School Education Program Authority and PR and DW Department on availability of basic amenities in schools impacting elementary education. As of now, data on the availability of basic amenities in respect of 24,633 numbers of elementary schools and schools having elementary section in composite schools have been entered out of 47,310 schools. The detailed information of schools in the prescribed has been uploaded in the website of the state government. Now is available in the public domain in complete order
And this correct. That I have given that format also, that prepared we also can find it from page 17. Well, I'll prepare an abstract out of this. The synthesis of this, I'll prepare an abstract. But in fact really is there. But in fact any other thing is required to be done. I'll prepare an abstract on this and assist your lordship on that. And also we have stated in paragraph 7, my lord.
Yes.
In paragraph 7, my lord, with the status, paragraph 7. That the school infrastructure status will gradually improve as a lot of projects sanctioned in the year 2023-24 are still ongoing. These are projects which are delayed due to the enforcement of the model code of conduct for simultaneous general election 2024. But these are going on. So there are also other new projects which have been approved under the Samagra Shiksha, Panchayat Raj and Drinking Water PR and Department, Rural Department, Department of Public Works Department during the financial year 2024-25. After completion of ongoing projects and new projects taken up this year, the status and available basic in schools will further improve. It is pertinent to mention here that the status of school is subject to change on account of both improvement and depreciation, improvement due to completion of so and so. But that you also have seen that page information available at page 70 deficiencies in this paragraph. Suppose in terms of the affidavit, the things are not available physically on the ground. They have taken this plea. If it is found, then they can say that it is improving or the project is going on or on account of this it is damaged. But all right, I don't want to blame them. Let us, I'll request Mr. Bhutia to take note of one aspect. I came across one primary school status. The district is even here in this affidavit also. Lordship will see the school on a tin structure. The whole school is functioning. It's only a whole structure is tin. Whole structure of primary school is tin. Can it be said that building is there, classroom is there?
It's a government school or private school?
It's a government school, primary school. It's a government
primary.
Yes. In Boiparigoda district of Koraput, kindly see that primary school, man. My lord.
That's not over. Yeah.
I can't believe such a school, whether.
This is the school.
Yes. It's a primary school. It came out in the newspaper. I came across that and I preserved it.
Tinore Tiari Nua Goda Nutana Prathamiko Vidyalaya.
Yes.
News type of school, it seems.
This. And they are saying that every school has permanent building in this affidavit.
So like you build for work,
Yeah,
you
let's not
are
pass.
making construction.
All right.
And I'll also take instruction on that school. I'll take note of that school's names. No, not only this. My lords observed. This is an example. I'll take instruction. School with regard to infrastructure. Not only this is a tip of the iceberg.
Oh,
only
they
one.
have to depend on the information provided by the.
But no, sometimes I'm visiting the schools also. I'm district-wise, selective schools, sample schools I'm taking up from the newspaper and going to those schools, collecting information, coming and giving information to my lords.
And Mr. Rath, there was one another newspaper article where the children are swimming.
Yes,
through
yes,
the
yes.
Flooded waters to
Yes,
reach the school.
yes. The road, the entire school is flooded with knee deep of
No,
water.
they can't reach the school.
No, can't reach the school. Knee deep of water.
That was also there in the
Yes,
newspaper.
yes. So if my lords permit, in fact, earlier I was permitted. If my lords permit, I can still take sample schools and visit those schools, give a report to my lords.
In fact, there can be a situation. See, if there is no building
Yes.
and education is needed,
Yes.
then should the authorities wait for a building to come before the education begins, the teaching begins? So some temporary arrangement, like even under the tree, the arrangements can be made. So if in order to overcome that situation, this arrangement has been made.
I don't
this
know.
arrangement
What is there? In
This
fact,
can
we do not
happen
know.
if suppose there are 10 students in an area having 20 villages or 10 villages.
Correct.
Then there can be a circumstance that
We do not know under what circumstances.
under
this have
what
been-
circumstance
Yes,
that
yes,
was
absolutely correct.
built.
But
That may
we
be
are
for-
not blaming. I am absolutely not blaming. My whole objective is to see that this things develop.
Yes, see,
Because in English medium schools, your lordships are getting digitized blackboard, AC, table, and entire facility with all ultramodern facilities are available. Then why a child will go to a government school with this kind of infrastructure?
see, at the same time, one cannot wait for that infrastructure to come before the education begins. So whatever stage, in whatever circumstance, with whatever infrastructure available, that will have to start. Otherwise,
That's
that
fine,
will-
but they will have to achieve that. That
we'll
that
have
is
to.
be-
That
yes,
the,
yes, yes,
therefore we are here
yes,
to monitor whether they
yes,
are doing
exactly,
something or not.
Exactly, exactly.
An additional affidavit has been filed by the commissioner cum secretary to the government school,
Government primary schools.
government.
I'm so sorry.
primary-
School and mass
School and mass education department, government of Odisha. A copy of the said affidavit has been served upon London amicus curiae on 12/8/2024.
12th of August.
The affidavit runs into
958 pages.
58 pages. First off, London Senior Counsel seeks adjournment to go through the contents of the counter affidavit and the documents annexed thereto, so as to give an effective assistance to this court. First off, next, after having perused the additional affidavit, we are of the tentative view that significant steps have been taken to taken in the direction of uploading of information on the website.
Yes, ma'am. Yes,
on the website of
Website of
the
state government.
department, website of the
State government.
Regarding the availability of basic amenities in the schools, in the primary schools. Information. Yes. Huh. When should we take up the matter? 1 week?
1 week.
List this matter on 1 week.
Will be 10th, 11th of September.
No. 4th. 4th. You want it? 11th of. All right, 11th. 2 weeks. 2 weeks.
Item 34.
In fact, nothing there. But we have not filed. Translation of Odia annexure in proper format. Different copies of Odia annexure in format.
Right.
Sorry, Lordship. Translation copies of the Odia annexures, Lordship, directed by this Honorable Court, that has not filed with proper format. In fact, that has been filed, but has not come to record, Lordship. That's why, Lordship, that any day, Lordship, that affidavit, in absence of that affidavit.
It is stated by learned counsel appearing on behalf of the petitioner.
Not petition, Lordship. I mean, opposite, but no, 5.
Was it party number 5?
5, Lordship. I have 5.
That English translation of the Odia version of which annexure?
Lordship, relevant person, 5 series, annexure 5 series, number of copies.
Annexure A by 5 series.
5 series.
It has been filed. Why are you saying it is not there on record?
Lordship, in fact, Lordship's direction was, Lordship, to file with an affidavit. We have given the translation copies, but notice says with not format, proper format. We have filed that with the proper format. Lordship, that has not come.
Filed on affidavit. Has been filed, you have filed.
Already filed, Lordship. That's not.
When?
Since long, Lordship, last 1 week back, Lordship, filed it. Filed.
Oh, you know the answer of Odia version of the relevant annexures have been filed, supported by affidavit.
Affidavit, yes.
Stop. This said affidavit is not there on record. Plus this matter on 1 week.
1 week, Lordship, this was matter 2 o'clock there, Lordship, Lordship had this matter. Any date, Lordship, 2 o'clock, so that it can be completed, Lordship.
Oops. 2 weeks, 2 p.m.
Right.
Lordship, grateful, Lordship.
Item 35.
35 may be taken up next week. Both of those are there. It may be taken up next week.
Can it be on Tuesday?
Tuesday after lunch. After lunch, fast. After lunch, Tuesday after lunch, fast.
Why 2 p.m.?
2 p.m. is fast.
Third of
Jointly request to list this matter on.
Second?
third Tuesday.
Tuesday is a good day.
2 p.m.
My senior wants to. I have no problem on Monday or Tuesday. My senior.
Third.
At 2 p.m.
Third 2.
Item 36.
On the last occasion, my lord, sir, please to direct me to file the reply affidavit in respect of the affidavit filed by the respondent 1 and respondent 5. Today, I am filing the affidavit and reply affidavit in respect of the against the respondent 5. But what the time may kindly be given on Friday, I will file the reply affidavit.
Installment.
Respondent 1.
You will file your affidavits in installment.
My lord?
You want to file affidavits in installments, like one affidavit today.
Because that respond to one affidavit is little bit, it contains some examination of some documents and other things, because some trust resolutions have been given, original copies have not been given, some extract has been given. So you require.
No, I have prepared the trust deed and all documents as you also required last occasion. I have also come with preparation to place those things. You also remember that case where, yes, the bank is the appellant with lordships against the judgment of the honorable single judge. And the amount of the trust which the institution is running, that has been kept. A fixed deposit that has not been released. You also wanted to know the nature of the trust and who are the trustees, how the trustees were seized.
And some villagers now, they have set up, my Lord friends,
Not set
a
up.
file and
Not set up now. I have filed the intervention application before the Honorable Single Judge itself. That was not dealt properly, therefore I am in an appeal.
You have not been set up. The parties have been set up. According to him.
No. Why the bank doesn't have any? Friday, my lord.
All right. We'll take up on Monday then.
Yes, my lord.
List these matters on Monday as requested on behalf of the applicant.
better us to take it up on Tuesday.
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 As requested on behalf of the appellant. BM Angul United Central Cooperative Bank. Yes. Tuesday at 2 p.m.
Item 37.
Please, my lords. This is that matter, my lords, reference.
Yes.
My lords, on the last occasion, I had made submissions before your lordship. My further submission before your lordship is that the view of the learned single judge, my lords, out of which this reference arises, my lords, is not sustainable in view of the fact that the division bench judgment also explicitly nowhere says that release is bad. The provisions of the act also nowhere say that it is bad. And that apart, there is another judgment of the Karnataka High Court, 2022 Live Law Karnataka 216, Ratnama versus State, wherein, my lords, the division bench of the Karnataka High Court has also interpreted Mohanlal and said that Mohanlal by itself doesn't bar, my lords, the interim release of vehicles and conveyances. The very basis of the learned single judge's order, that is the division bench decision reported in 2022-85 OCR 713. In that division bench decision also, my lords, their lordships nowhere said that it was barred under when cases are instituted under NDPS Act, that interim release is barred, my lords. And that aspect has been taken note of when the order was passed by Justice Sahu, making the reference to your lordships.
Yes.
And in fact, there is another division bench judgment, that is 2022 volume 85 OCR 705, where the very same division bench which decided the other matter, that is 2022 85 OCR 713, expressed the view that, so therefore, my lords, the single judge view of Justice Pujari is probably not proper, and that also cannot be said to be the correct proposition of law flowing from the division bench. So the entire basis, my lords, your lordship will see Mohanlal itself. Mohanlal nowhere says so. The apex court and the apex court's judgment on which
Mr. Panda, we could not hear you for 3-4 minutes. So could you please repeat what you said?
I'm sorry, my lords. Now, what
No, you will not hear you.
What I was trying to say, my lords, is that the single judge judgment which has been referred of Justice Pujari, my lords, the view that he held, it doesn't flow from the division bench judgment on which he says that on the basis of the division bench judgment, interim release is bad. That's what I want to impress upon your lordships. Because on the same day that that division bench judgment was delivered, which is reported in 2022-85 OCR 713, another division bench judgment was also delivered. That is reported in page 705 of the same volume of OCR, which is Ashish Ranjan Mahanti, advocate versus State of Odisha. In Ashish Ranjan Mahanti Millards, the same division bench Millards took note of it before it that section 36C of the NDPS Act indicated that provisions of CRPC will apply to proceedings before a special court, except otherwise provided.
Mr. Pandey, where is that order? Which page is the order of reference?
Lord, I don't have a copy of the reference order. I was simply asked to assist your lordship.
Yes, yes, yes.
I think it will be order dated 23/8/2022. In criminal
In which
revision
case?
number 36 of 2022.
Oh,
That is order of Justice S.K. Sahu Bilals.
Yes, yes.
Has your lordship got it?
yes. Order dated 23/8.
Yes, my lord.
Order dated 23/8.
Yes, 23/8/2022. If your lordship will look at that order, your lordship may see the third page of that order. The paragraphs are not numbered. I'm sorry, my lords may see the fourth page of that order. The paragraph begins, learned counsel further submitted that in section 52A of the NDPS Act, there is nothing which bars applicability of 457 CRPC. Has your lordship got it?
Yes.
Reference was also placed on the decision of the Honorable Supreme Court in the case of Sundarbhai Ambalal Desai versus State of Gujarat, wherein the Honorable Court, after analyzing relevant provisions of the CRPC, His Lordship has quoted paras 17 and 18, my lords. And then His Lordship again refers to another decision of the Supreme Court reported in 2010 6 SCC 768. And that is with regard to the fact that vehicles are lying in the police station for months and years together, for which they were required to be, a disposal mechanism was required to be framed. Now then, my lords may look at the same order. The paragraph begins, in view of the decisions of the Honorable Supreme Court. That will be at internal page 9 of the order.
Yes.
In view of the decisions of the Honorable Supreme Court, in the case of Sundarbhai Ambalal Desai, General Insurance Council, and the division bench of this court in the case of Ashish Ranjan Mahanti, so also single bench of this court in Jitendra Kumar Digal, I respectfully disagree with the view taken by my learned and esteemed brother, Honorable Justice S. Pujari, in the aforesaid criminal revision petitions, that the prayer for release of the vehicle in question under 4 CRPC no more survives, being subject to pre-trial disposal as per section 52A of the NDPS Act. Then, referring to another judgment of this court, reported in 2014, volume 58, OCR 1050, the court says, law is well settled as held in that case that in view of section 5 of the CRPC, if the special act doesn't indicate the specific provision for inquiry into trial or otherwise dealing with such offences, then procedure of CRPC would be applicable. Thus, when special law prescribes for a special form of procedure enumerated under CRPC is not to be followed. Only when special law or local law doesn't provide the procedure or dealing with the offence under the special or local act, procedure contained in CRPC is to be followed. If your lordship is seeing the NDPS Act, I would request your lordship to kindly see section 50 1 million. Section 36A, my lords, in section 36A, the Act says that offences are triable by special courts, notwithstanding anything contained in the Code of Criminal Procedure. And says that all offences punishable with imprisonment for more than 3 years are to be triable by the special court. And when somebody is to a magistrate, section
36A has no application.
Yes,
for this reference.
No, for this
36
reference,
deals with trial.
Yes, for this reference, your lordship may kindly look at section 51.
Yes, 51 is applicable.
Yes, it says that the provisions of the Code of Criminal Procedure shall apply insofar as they are not inconsistent with provisions of the Act. Then my lords may see section 52 also.
Yes.
Section 52 deals with disposal of persons arrested and articles seized. It says, any officer arresting a person under 41, 42, 43 or 44 shall as soon as may be inform him of the grounds for such arrest. Subsection 2 is relevant for us. Every person arrested and article seized under warrant issued under subsection 1 of section 41 to be forwarded without unnecessary delay to the magistrate by whom warrant was issued. Subclause 3 says, every person arrested and article seized under subsection 2 of section 41, 42, 43 or 44 shall be forwarded without unnecessary delay to the officer in charge of the nearest police station or the officer empowered under section 53. And then subclause 4 says, authority or officer to whom any person or article is forwarded under subsection 2 or 3 shall with all convenient dispatch take such measures as may be necessary for disposal according to law of such person or article. And your lordship may note that the word article is not defined in the NDPS Act.
How do you deal with
That is disposal. 52A.
Yes. 52A is central government may, having regard to the hazardous nature, vulnerability to theft, substitution, constraint of proper storage space, or any other relevant consideration in respect of any narcotic drugs, psychotropic substances, controlled substances, or conveyances by notification in the official gazette, specify such narcotic drugs, psychotropic substances, or conveyance, or class of narcotic drugs, class of psychotropic substance, class of controlled substances, or conveyances, which as soon as may be after seizure shall be disposed of by such officer and in such manner as government may from time to time determine after following the procedure hereinafter specified. In terms of 52A, my lords, 2 notifications have been issued. One is of 2018 and another subsequent. And the second notification deals with conveyances, my lords.
Yes.
Now, those notifications have been dealt with, my lords, in Mohanlal's case. If your lordship if my lord will see Mohanlal's case reported in 2018-17 SCC 627, my lords. Yes.
There, their lordships have referred to the notification. Just a moment. The second notification, the notification dated 16/1/2015 provided for disposal of conveyances also, my lords. I'm just pointing out. My lords may see these I'm sorry, your lordship has to look at 2016 3 SCC 379 million.
2016
volume 3 SCC 379.
Yes.
There, my lords, the court referred to its earlier order.
Yes.
My lords, just a moment, I'm just taking out that. That is decided on 28th January 2016, Mila. The relevant paragraph.
Yes.
Paragraph 3, my lords may see. It was in the above backdrop that by an order dated 3rd July 2012, passed in Criminal Appeal 652 of 2012, this court directed collection of information from police heads of each one of the states through the chief secretaries of the states concerned to serve the same upon the DGs for a report to be forwarded through registrars generals of the high courts of the states concerned who were appointed nodal officers for that purpose. And if your lordship will look at the last part of that subparagraph, the queries raised by this court were in the following words. 12.1 seizure. What narcotic drugs and psychotropic substances, natural and synthetic, have been seized in the past 10 years and in what quantity? Provide year-wise and district-wise details of seizure made by the relevant authority. The second query was the steps, if any, taken by seizing authorities to prevent damage, loss, and pilferage of narcotic drugs and psychotropic substances, natural and synthetic, during seizure transit. Third, my lord says, what are the circulars, notifications, directions, guidelines, if any, issued to competent officer to follow any specific procedure in regard to seizure of contraband, storage, and production? Copies be attached to the report. Why I am laying emphasis on this is that the conveyances are not questioned here. The court was concerned only with the drugs, my lords, not with conveyances. Similarly, 12.2 storage also, my lords, the court is concerned only with the drugs, my lords. Disposal also 12.3, the court is concerned with drugs, my lords.
No, because the court was looking into the court in case of Honlal was looking into disposal of mainly of drugs.
Yes.
And therefore reference is to the drugs.
Right.
Now see the section 52A.
Yes, my lord.
52A specifically lays down how the seized drugs and conveyances shall be
Conveyance.
disposed of.
Right.
Then it further provides that they shall be disposed of in accordance with the procedure prescribed. So this provision will have to be read with the procedure prescribed for disposal of conveyances.
Yes, Milord.
457 may not apply because 457 is general provision.
That will
457 is general provision. 50.
Yes, Milord. It will depend only upon
everything. Exactly. So everything will depend on the nature of the provisions in the notification.
Yes.
So therefore, we wanted to see the notification, like not as mentioned in the Mohanlal, but as they are, as the notification. So whether the notification is there on record or somewhere.
I'll check that.
No, volume, in the commentary, we can get that.
The 2015 notification, Milords, I have a copy that is published in the Gazette dated 16th January 2015.
See, many of the notifications have been issued because of Mohanlal.
Yes, Milords.
Some of the notifications, yes.
Can I place, Milords, the portion of that notification of 2015?
Place that, the relevant provision?
Yes. It says, subclause 2 says, items to be disposed of. All narcotic drugs, psychotropic substances, controlled substances, and substances shall be disposed of under 52A of the said Act. This is the notification of the Department of Revenue dated 16th January 2015. So it says 52A is the procedure that is to be followed.
No, 52A.
52A says it will be done in the manner which the government by notification may prescribe.
Right, Milords. And this notification then says who are the officers who will initiate. The manner is at clause 4. Shall I read that clause? It reads, where any narcotic drug, psychotropic substance, controlled substance or conveyance has been seized and forwarded to the officer in charge of the nearest police station or the officer empowered under section 53 of the Act or seized by such officer himself, he is to prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances in terms of Annexure 1 to this notification and apply to a magistrate under section 52A subsection 2 of the Act. As per Annexure 2 to this notification, within 30 days from the date of receipt of chemical analysis report of seized narcotic drugs, psychotropic substances, or controlled substances. So he has to wait until he receives the chemical analysis report. Then he is to make an application, Milords, to the concerned court, Milords, or magistrate for disposal.
Mr. Ponda, this also relates to the conveyance.
Yes, it does. Then
But
what they say,
Mr. Ponda,
is the court going to wait?
No, 52A
Yes, my lord.
says this is for speedy disposal actually. If they have to wait for the medical examination report, the purpose is.
Exactly, my lord. The purpose is not solved at all. Because as your lordship rightly has said, this getting the report may take months. Of the seized items to the chairman of the drugs disposal committee for a decision by the committee on the disposal, and will send a copy and details with the items seized to the officer in charge of the godown. There, my lords, a drugs disposal committee is required to be constituted under subclause 5 by the head of the department of each central and state drug law enforcement agency. And this drug disposal committee will be conducting detailed review of the seized items and passing orders for disposal of the seized items. Now, I am not sure whether the state of Orissa has constituted such a committee or not.
Yes, yes. Mr. Samantray.
No.
Committees have been instituted, they may not be functional, but
They have, I think. You've been submitting reports, I think, periodically before this court in that Ashish Ranjan Mahanti case regarding this, or registrar versus.
Yes, in
Yes,
register.
yes.
Then the very same section it says, for disposal of seized items, there is a table at clause 8. It gives disposal powers of heroin, hashish oil, ganja, cocaine, and mandrax, my lords. Poppy straw, other narcotic drugs, psychotropic substances, and controlled substances or conveyances up to the value of rupees 20 lakhs. And the mode of disposal is given in paragraph 9, clause 9, my lords.
clause 9 of?
Clause 9 of the notification. Mode of disposal of drugs. But the mode of conveyances, my lords, I don't think is there. Conveyances are probably to be auctioned off, my lords. But that auction will be only on confiscation being complete. Yes, clause 9, subclause 5, and further subclause E says, seized conveyances to be sold off by way of tender or auction as determined by the drugs disposal committee. Lords, there will always a gap, my lords, until this tender, this committee, my lords, takes up the matter. During that period, the magistrate continues to exercise power in view of section 51 of the NDPS Act itself.
All right. Yes. Anything else, Mr.?
And the same view, my lords, the Karnataka High Court's division bench has taken in that Ratnama, my lords, versus state, my lords. And a single judge bench of the Karnataka High Court has also reiterated the same view. And there are judgments of this court of various single judges wherein the courts have held that power continues to be there with the magistrate to pass orders of interim disposal.
All right.
Rider is that the vehicle in question should not be involved in the offense with the knowledge of the owner. That is the only rider which this court has imposed.
Yes.
Just to assist your lordships, my lords, I am also appearing for one of the petitioners in one of the case, my lords. On the last occasion, my lords, I had given a compilation, if your lordships may recollect, wherein, my lords, I have made my submissions as well as I relied upon certain decisions, my lords, including that of Mohanlal as well as my lords, the division bench judgment of this honorable court. Today, my lords, I'm just giving two more judgments, my lords, for your lordship's reference, my lords. Wherein, my lords, I have referred to that Ashish Ranjan Mahanti's case, which my senior just pointed out. And my lords, one single judge judgment of the, my lords, the Honorable High Court of Patna, my lords, of the year 2024, my lords, wherein the Honorable Judge, my lords, has surveyed all the decisions, my lords, of various high courts, and has held, my lords, ultimately, my lords, that under the special judge can exercise that power under 457 or 451, my lords, as the case may be. And my lords, the direct, and there is no bar for interim release of a vehicle. The rider, as my learned senior pointed out, my lords, that the owner should not have been implicated, my lords. And at least in my case, my lords, the charge sheet has been filed, my lords. The owner has not been charge sheeted, my lords. So
then we have to answer the reference whether you are entitled for release or not. That will depend on.
And so far as the observations of the learned single judge, my lords, which has to be considered, my lords, passed in CRL REV number 404 of 2020, my lords, which is also being considered, my lords. My lords, that needs to be reconsidered by your lordships, my lords, because what the honorable single judge has held, my lords, that the petitions under 451 or 457 can only be filed by the prosecuting agency, my lords. If that be so, my lords, then the owners, my lords, will be left to the whims and fancies of the prosecuting agency, my lords. And whether they if they don't file it, my lord, the vehicles will simply be, my lords, lying in the.
Yes.
So that is my respectful submission, my lords. So that has to be reconsidered by your lordships, my lords.
Yes. All right.
Nothing to add. Lordships had
I'll file a note.
It's not nothing to add.
Please submit, Mr. Panda.
My senior milord says amicus curiae has guided the lordships, so nothing more to add. But only thing is that last occasion lordships are saying that the Ratnama judgment, Karnataka High Court, milord. There they said that application under section 457 is maintainable, milord.
In fact, that is what we have to decide, whether it is maintainable or not.
Yes.
That is the question.
Yes, the basic question that my lords are now to decide is that until the DDC takes up the matter, whether the magistrate is denuded of powers. Because the DDC can only take up the matter on an application being filed after the report is received from the chemical examiner. So during that hiatus, my lords, to say that a person is without remedy, that will probably, my lords, I think, be somewhat harsh.
Third, final floor.
Para 53 of Ratnama judgment, my lord. Very important. See, time see the Karnataka High Court judgment, my lord. Para 53, my lord.
Have you given that judgment?
Yes, yes. Last year. Para 50.
Yes.
Para 50 on analyzing the provision of NDPS, particularly the amended provision of section 52A of NDPS, the notification dated 16/1/2015, it makes it clear that earlier in there was no provision regarding the pre-trial disposal of seized narcotic drugs and psychotropic substance. The storage of seized narcotic drugs and psychotropic substance up to final conclusion of trial of this case created many problems. Thereby, section 52A of NDPS Act 1985 empower the central government to prescribe by notification the procedure to be followed for seizure, storage, and disposal of drugs and psychotropic substance. So, counter the problem like vulnerability to the theft, substitution, constraints of proper storage space, and other relevant problems, the central government, in exercise of the power, had issued the said notification, which is prescribed the procedure of pre-trial disposal and destruction of seized narcotic drugs, psychotropic substance, and conveyance, but the legislature has not given any power to drug disposal committee to decide the claim of a person who claimed conveyance vehicle seized under NDPS Act for illegal transportation of any narcotic drugs and controlled substance, as he has given by the legislation to the special court under section 60 and 63 of NDPS Act. where a person claims for release of interim custody of a seized vehicle seized under provision of NDPS, no provision is provided in the notification to decide the interim claim. Thereby, the provision of Section 63 NDPS Act would prevail only on the provision of notification issued by the central government under Section 52 of NDPS Act. The provision of Section 63 of the said Act envisages that seized conveyance cannot be disposed of without deciding the claim of the person who claimed that conveyance and the power to decide the claim of such person is only given by the legislature to a magistrate or a special court under provision of Section 52 NDPS Act. The word confuse is not used because trial is yet to come, and it is discretion of the trial court to confusion or not to confuse conveyance seized under NDPS Act as per the legal provision.
Yeah. Yes. Next.
Item 38.
May it please under. Lord, in this, there are two writ applications before your Lordship, Lord. In 3163 of 2022, the petitioners were appointed as court managers before framing of any rules, my lord. In pursuance of the directive of the Honorable Apex Court, my lord, in the Judges Association's case, my lord. In these Supreme Court, while hearing the matter, earlier directed that the court managers already appointed should be absorbed, shall be absorbed, my lord.
Where is that?
By way of regulation, my lord. That your Lordship, my lord, I have given to your Lordship two dates, has your Lordship got it?
Two page what?
357, annexure 43.
Yes.
I have also given a, your Lordship will find a compilation of judgments. I have given, my lord. 357. Your Lordship would get the relevant page. Flag mara ହେଇଥିଲା Lord, page 370, your Lordship, may I draw your Lordship's kind attention to page?
Yes, we are there at 370.
Lord, para 9. Professionally qualified court managers, preferably with an MBA degree, must also be appointed to render assistance in performing the court administration. The said post of court managers must be created in each judicial district for assisting principal district and session judge. Such court managers would enable the district judge to devote more time to their core work, that is judicial functions. This in turn would enhance the efficiency of the district judicial system. These court managers would also help in identifying the weakness in the court management systems and recommending workable steps under the supervision of the respective judges for rectifying the same. Then this sentence, the services of any person already working as a court manager in any district should be regularized by the state government as aware of the considered view that their assistance is needed for a proper administrative setup by the court. Then the court managers and also the Odisha High Court
has been regularly writing to the, prior to this,
So when was this order passed? What is the date of the judgment?
the order is 2/8/2018, my lord.
And when were the court managers appointed?
The managers were appointed, my lord. Has your lordship got that date set?
Yes, we have. We do have the,
That is
yes.
8/8/2011 advertisements were issued,
Yes.
and the 6/3/2012, that is annexure 4, my lord.
Yes.
What is I got letter number 2 upon selection of 32 court managers to join on 2/4/2012, my lord.
Yes.
Then your lordship will find that several letters has been addressed to the state government. I will take your lordships to the annexures, but let me briefly tell. Several letters were addressed to the state government by the registry to regularize these court managers. And all along government was telling that it is under active consideration.
So
Then-
are you still continuing?
No, no. The
Since when?
second writ application, so I challenge 3163, I came up before your lordships, before the rule came into force, praying for regularization and also challenging the rules, my lord.
Oh, no.
Pani, pani.
On the date when the order of the, when the judgment of Supreme Court was done.
I was there in the service.
You were there in service?
Yes,
How do you say?
my lord. I was disengaged 31st August 2022.
Where is that order?
That order is, I have given, my lord. 18. Thirtieth August, my lord, annexure 40.
Annexure 40.
Yes. The 3167.
40. 14.
Yes, 40.
40. Their case. IE number.
40 is 2? 40.
40 is annexed to what? The writ petition or?
That is annexed to interim application 12129 of 22.
That is not given. Oh, the IAs are not marked, so that is.
That is not there in the running page.
No. Because the annexures, they have not page marked, so that must be after the counter.
In the secondary, it has been filed as annexures, my lord. Where I have challenged this order, secondary annexure 10, my lord, page 69, my lord.
So this is different.
My lord?
See, the Supreme Court said
My lord.
that all the persons who were working, their services should be regularized. And in the light of the Supreme Court's observation, an exercise was undertaken to regularize their services. And for that purpose, your suitability for absorption was being considered. And you were not found suitable.
That came in 2021, my lord.
So that came in 2021. See, there was a Supreme Court decision.
Direction to regularize all those who are working on that day.
All right, working on that day, that would not mean that irrespective of your suitability, you should be absorbed. So therefore, it is not that the court took up this exercise of absorption in the light of the Supreme Court's decision.
No. My submission is that
again asking me to undergo a suitability test for absorption was not required in view of the fact that I was regularly, there was advertisement, there was a selection committee, I appeared in written, appeared in viva, and Supreme Court clearly directed that you regularize all those persons working as on that date, my lord. And in pursuance of that, various high courts and district courts throughout India, various states regularized their services. In some of the states that undertook similar exercise, that of Orissa, let's assume for the sake of the argument that in pursuance of the Supreme Court judgment, an exercise was taken by the High Court of Orissa by framing a rules. Similar rules were framed in other high courts also. They were challenged in judicial side. And in judicial side, those they were set aside. In some cases, they were directed, the government to come up for regularization, government regularized them. And in other cases, High Court directed reinstatement of those persons who have already been terminated, in case of state of Telangana, and to regularize their services. So the state government complied and came up. But so far as our state is concerned, in spite of the assurances given to the High Court prior to this rule came into force, that we are in the process of regularizing all these court managers, they were subjected, they came up with a rule and they were subjected to suitability test. Some of them succeeded, some of them didn't succeed. Your Lordship directed that without prejudice to your claims, you appeared. And we appeared. And also, when the rules were challenged, your Lordship told that it would be any exercise in pursuance of this rule will be subject to the writ application without prejudice to the right of the petitioners. So that is how I am for your Lordship. But since during the pendency of the 3163, our services were terminated in 2022, therefore, I again, by way of abundance concern, in spite of the interim of the order, that it will be abided by the result of this writ application, I filed another writ application and got it tagged with him. That is how I am before your Lordship. Now, Lordship, permit me 15 minutes, so I can complete.
All right, tomorrow?
Please, all right. Your Lordship may fix that matter at the first hour or 2 o'clock as your Lordship pleases.
Tomorrow we will take up.
All right.
Because
I have another prayer in respect of another case. That is,
so what do you want?
Lordship's board below. If your Lordship remembers that item number 55, that tender matter, where I was asked to give additional performance security, and the clause was there in twice, it was there was a confusion. Your Lordship has issued notice, they have appeared.
You are arguing which matter? 38 or 55?
55. Counter, they have admitted inadvertent error, and your Lordship, though has granted an interim order, since it is a work of contract of railways, if your Lordship can give me some time.
All right, so when do you want?
And whenever it is convenient to your Lordship.
Monday?
All right.
Tuesday. Monday, in the first half, I may not be here.
Tuesday, then your Lordship
Tuesday.
gives me time, Lord, at 2 o'clock. I know it is
My
very...
Lord, I will small submission, my Lord. In item 30, my Lord Senior is arguing the matter. In that case, Law Ministry implemented a party opinion number 5. I think this Law Ministry can have a no role to play. She may delete it because
no, Law Ministry
Ministry of Law and Justice implemented opinion number 5.
Might have been implemented as a party because
Because on the basis law ministry has been made a party, in fact, they do not have much to do with the virus and the termination.
Yes.
But we have made them parties because the on the acting basis of finance department and law ministry is direction that there should be regularized. So that is why certain
All right,
documents.
we will consider the next sitting.
My lord,
Tuesday at 2.
tomorrow it will come
Okay,
at
go.
2 p.m. 2 p.m.
Tuesday.
Tuesday. Or Wednesday.
Like 38.
Huh?
38 is Tuesday. The other one.
Other one is 55, my lord. That is a Tuesday. 38, my lord.
Next week we will take up.
This matter. 38 and 55.
No, 38.
38. 55.
55.
That tender matter.
So 55, let that be taken up.
What?
You are taking advantage of your appearance in item number 38.
No,
So we'll fix the time.
because an interim order is operating in my favor.
Right.
But
All right, we'll fix it. We'll fix it.
38 tomorrow, my lord.
No, 38 on
4th September.
4th September at 2 p.m.
Okay. Well, I don't want to take advantage of my
No. We know,
at
Mr.
any point of time. That is why
That was on a lighter note, Mr.
mark that I always see it in the court.
We understand, Mr.
Item 39.
I think I am for the petitioner, my lord. Filed a petition for amendment that is at flag B.
Copy of a interim application may kindly sort.
I'm preparing for OP4, my lordships. A copy of the interim application be
Serve
served.
upon them. An application has been filed by DIA number 3439 of 2024. Copies of which have not been served upon London Council representing the estate and OP number 4. Let it be done. Stop this matter on Tuesday.
Item 40.
And job contracts claiming regularization. That is the issue, my lord. 40 item.
Substitution.
May I pray, my lord, let this matter be taken up on Monday, my lord.
Because I think she has already appeared, but you need to file an application.
Application. This matter come on Monday because that's what it should take instruction.
Yes. Who has appeared? File an application for substitution. Have you filed?
I have not filed. Yes. I have not received the instruction from the department so far as the legal representatives. Of
All right. It appears that the respondent number so and so. Responding.
Number 1.
Number 1. Died during dependency of this appeal. So stop. List this matter on 3 weeks. Stop. In the meanwhile, it will be open for the applicant to seek substitution consequent upon the death of the contesting respondent.
So 41.
In item 41, I have filed an interim application for substitution, that is IA number 6063 of 2024.
6063.
63, my lord.
6065 is there. 606.
Thereafter. No, sorry. So item 41. Oh,
6063 of 2024, my.
just one more.
Sorry.
Upon filing,
It's not have scanned. It is 60.
63.
should be 6065. You can correct your own.
6065. Ma'am.
Yes, you are for whom?
I am for the opposite parties,
For the respondents.
for the respondents, my lord.
You are representing the legal heirs also.
No, my lord. Not at discipline. A consolidated petition may be. Some of the respondents have died. Respondent number 3, 7, 10, 14, and 17.
We are issuing notices to them.
Those. Well,
Unless they appear sumato.
Number 6065 of 2024. This application has been filed for substitution consequent upon death of respondent number 3, respondent number 7, respondent number 14, and respondent number 17. So, the details of the heirs and legal representatives of the said persons have been mentioned in the schedule to the application. Stop. Issue notice to the proposed to the persons proposed to be substituted in place of the deceased respondents as mentioned in the schedule. Both issue notice. Yes.
42.
Requisites within 3 days.
Yes. The date may be fixed, my lord.
6. Let's see. Yes.
42, yesterday's matter, black mark, that your lordship wanted to see the judgment rendered by the tribunal, which has been affirmed by this court in the writ appeal. Is the I've given 2 copies each. The tribunal order as well as. Preparation. Basic preparation.
All right. So the 42 or 43? 42.
42, man. 42.
42. There is no representation.
No, my lord, but it was there, he was there yesterday, but somehow he's
Where
not.
is- where you sent us something?
Oh. I requested on behalf of the respondent, this matter on Tuesday. There is no representation on behalf of the respondent, this case on Tuesday. I thought in the morning.
No, yesterday he was saying that he has a problem today.
Pardon to mention, my lord.
46. This may have to be referred to larger bench. Because whatever maybe the kind of decision that will have to be.
But my lord, so far as the tribunal's decision was only confirmed by this court in writ appeal. But as such, with respect to the effect of the black mark as prescribed in 837.
No, that has been accepted by this court.
Yes.
The court, the revision bench states records that it had gone through the records and provisions and then.
Yes.
Therefore.
My lord, serial number 46, regularization in case of outsourcing agency. My lord, a similar matter.
Just a minute.
46.
46, yes.
Outsourcing regularization, similar case of serial number 5 and 6, posted to 23/10/2024.
Why that is Patita Bhavan?
Yes. Supreme Court pending in the before the.
No, but outsourcing matter, one matter has been decided by this court.
No, my outsourcing matter that your lordship, that honorable single judge has allowed the writ petition. Your lordship has fixed that matter in July, that has not come.
Oh.
That a batch of matter that writ appeal number 127 of 2021.
Okay.
127 or?
2021.
No, but very recently you can find out.
Yes, my lord. In one case, perhaps your lordship decided that in where BS, learned friend BS Tripathi was arguing that matter that is against the central government.
Those nurses.
Nurses, that your lordship allowed that. Disallowed that.
Disallowed.
Honorable single judge has disallowed that they are not entitled.
He was continuing.
So your lordship also dismissed his writ appeal.
Yes, so where is that decision?
I can give it to member, but a batch of writ appeals are pending before my lords.
Therefore, that can be taken into account in those. Yes. Just give the number.
Pardon to mention, my lord.
My lord,
Item
46
60.
may be posted to 23/10.
Now, if it is similar to the batch matters, a date can be fixed. Is it similar to the batch matters? What the matter which is?
The cooperative matter.
Cooperative bank employees, my lord.
Your cooperative bank.
Yes, ma'am.
2 weeks will come after 2 weeks.
Interim order may continue.
Interim order.
I think challenge.
Do-
Challenge it so that.
Double area interim order.
Interim order shall continue in the meantime.
My lord,
the bag may also be directed not to take any coercive action against the respondent numbers 1 to 11. There also,
How can we do that in their appeal?
now they are extending threat that they will be out of service as the judgment has been stayed, my lord.
So we can decide it tomorrow. Or right now, it's 4:30.
Yes, that's it.
Can we decide it right now?
My lord, I do not object to any adjournment prayed for by my respected senior. I
No,
respectfully.
we will take up the matter. You are right that this matter should be urgently decided. Because post this matter on. 8 week time. 1 week. Not 1 week. Not this week. Don't that. 2 weeks. 2 weeks to be taken up. 2 p.m.
After 2 weeks.
Yeah, after 2 weeks, 2 p.m.
Yes.
Item
43, yes.
I'm appearing for the opposite party number 5 matters.
Yeah.
The stay has not been extended, but I am in favor of me. The agreement has been executed, but the state is not allowing me to do the work, my lord.
All right, other matters will be taken up in due course.
Item 60, my lord. Now, it's a tender matter. Your lordships had issued notice on the last occasion, but in the meantime, they have issued a work order and signed an agreement with one of the bidders. Lordships may take up this matter tomorrow at 2 p.m.
We will try. We'll try and make a mention tomorrow.
Highly obliged, my lord.
Tomorrow all matters are coming. Make a mention on Monday.
My lord, can it be taken up on
Monday.
Highly obliged.
My lords, item 43, can it be Tuesday, my lords?